Good morning, Ms. Franklin. Can you
Good
please
morning.
raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Can you please state and spell your name for the record, please?
Catherine, Kathryn, Franklin, Franklin.
And Ms. Franklin, before you go further, there's a microphone there. If you'll just, you can bend it to whatever height you need, but it's hard to hear if you're not speaking into the mic. Thank you.
And Attorney Franklin, can you tell the hearing panel how long you've been a member of the Georgia Bar?
16 years,
And what's your area of practice?
family law.
Okay. And do you know Brandy Alexander?
I do.
And do you know her personally and professionally?
I do.
Can you describe the nature of both your personal and professional relationship with Brandy Alexander?
We're friends. I started representing her as counsel in, I believe, 2014 or 15. My daughter has also babysat for her daughter.
And to the extent that you're friends, how long or how far back does that friendship extend?
It would have predated my being retained as counsel. I'm going to say probably 2010 or 11.
Okay.
I don't remember exactly.
Are the two of you members of the same sorority?
I am not a member of a sorority.
Okay. All right. Fair enough. But friends enough that at some point there was some babysitting assignments between the two of you and your families.
Yes.
Okay. And to the extent that you represented her back in or around 2014, what was the scope of that representation?
It was a family law matter. There have been quite a few over the years. I don't remember specifically. It would have been something involving custody.
Okay. Turning your attention to 2021, September, October of 2021, do at some point you recall being hired by Ms. Alexander to represent her in a petition for the change of visitation related to her child, Candace?
Yes. I mean, I was already representing her.
Okay, all right. Has your representation always been as it relates to her child, Candace? Or
Cadence.
Cadence, I'm sorry.
Yes.
Okay. And so did you represent her back in October of 2021 regarding this matter?
I did.
Okay. At some point, we've talked on the outside of the hallway about your representation and certain conversations that you've had with Ms. Alexander concerning that representation. True?
We have not talked about the content of any conversations that I've had with
Sure,
my client.
yes,
but
sure.
the existence of those conversations,
Right.
yes.
And so I'm going to reserve the right to ask her at some later point, if necessary, about those questions. I'm going to go to another area. At some point, ma'am, can you describe whether or not the proceeding that you were handling in 2021 was a contentious proceeding between Ms. Alexander and the father of her child?
Oh, I'm not sure how to answer that. Contested custody cases are, by their nature, contentious, yes.
Okay. All right. Do you recall ever being on a three-way call with Miss Alexander and anyone related to the custody matter?
No.
Were you ever on the call between Miss Alexander and Judge Williams, for example?
Absolutely not.
Okay. Were you ever on a three-way call where you were not necessarily participating in the call, but at some point, did Miss Alexander ever put you on speakerphone to listen to a call between her, being Miss Alexander, and Adeline, Adidion Aaron?
On speakerphone, meaning I would have been on one side of that call or the other, not on the call. You're asking whether I was on the call on speaker or whether I was near one of them who had the call on speaker.
Right, and so I thought when we talked out in the hallway and I asked you whether or not Brandy Alexander had put you on the speakerphone and you listened to a conversation with Brandy Alexander and Adidion, you told me no, but I learned of the call shortly after, and that's why I headed back to Brandy's house.
Okay, I misunderstood your question. What I thought you asked me was I on speakerphone? I was confused about your question. Was I on speakerphone with Brandy with a call with Adidion? Is that your question?
That is my question.
Okay. I do not believe that happened. I believe that I learned of that call from Brandy immediately following that call, or between calls. I think there might have been more than one call.
Okay. At the time that you learned of that, I think you indicated to me that you were headed to a location. Where were you headed?
I was heading through downtown Atlanta to McDonough
Okay.
for another case that didn't involve Brandy.
And then at some point you got a call from Miss Alexander who told you essentially that she had talked to Adidion.
I am not going to comment on what Brandy told me or
Okay.
any communications between myself and Brandy.
Well, let me ask you this question. As a result of receiving a call from Brandy Alexander, did you then change course and ultimately go to Brandy Alexander's house?
I did.
Okay. And just to be clear, you never overheard any conversation between Brandy Alexander and Adidion. True?
I believe that's true, yes.
All right.
I don't specifically remember that.
Okay.
I'd like to add to that, though. While I was at Brandy's house, I believe she was on the phone at some point with Adidion.
Okay.
She was not on speakerphone,
Okay.
and I was on the balcony.
Okay. You could hear Brandy, but you could not hear Adidion. True?
True, but I wasn't particularly paying attention to the phone call.
Okay.
I mean, I could hear her talking, yes. I don't know the contents of that conversation.
All right. Those are my questions. Thank you.
All right. Any follow-up for Ms. Franklin?
Briefly, with that phone call, when you said you could hear her talking, did you mean you could hear Brandy talking, or you could hear Adidion talking?
I could hear Brandy talking.
Okay. Was there some point during that phone call where you had come in and you were in the kitchen when Brandy was still on the phone?
Yes, although I can't specifically say whether Brandy was on the phone with Adidion or with another attorney
Okay.
at that time. But yes, I was in the kitchen at one point and she was on the phone.
Okay. On October 18th of 2021, you called Judge Williams' chambers to inquire about the process by which one could obtain a senior judge, correct?
Correct.
Okay. And who did you speak to when you made that call?
Her name was Janelle Bowles or Bowler.
Okay. During that phone call, did you identify yourself by name?
Yes.
Did you identify the fact that you were representing Brandy Alexander in one of her cases or in a case?
Yes. That was the reason for my call.
Okay. Did you provide a case number?
I don't specifically recall if I provided a case number, but generally speaking, when I speak to judges' staff, I do provide the case number.
Okay. And did to return a call to you?
Yes.
Okay, and did you request a return phone call?
Yeah, well, I don't know if I requested it or they offered it, but when I spoke to her, she wasn't sure how to answer my question. And what she said was that she would check with Judge Williams and she would call me back.
Okay. And your question was, how do we go about obtaining a senior judge, correct?
Right. I wasn't sure, some judges are, have different procedures than others. I wasn't sure whether it would require a formal motion or, what Judge Williams, how she wanted to handle that, because she was relatively new at that time.
Okay.
And I had never been in her division before in a case, so I wasn't sure how to handle it, so that's why I called.
Okay, all right, thank you. That's all I have.
Just briefly. At some point, the issue of recusing Judge Williams from Brandy Alexander's case came up, did it not, during the course of your representation?
Yes, it came up.
You did not file a motion to recuse Judge Williams, true?
True.
And in fact, my understanding is that the issue of recusal came up at or around October, at some point in October of 2021. Is that true?
I don't recall
Okay.
specifically when it came up. I don't recall. It would have caused me concern once I learned of a phone conversation between Judge Williams and my client. However, I don't remember exactly when that was.
Okay. I mean, do you recall how soon after the phone call that you learned of the phone call between Brandy Alexander and Judge Williams?
Immediately.
Okay.
I just don't know. I don't know when that was. It
Fair
was the
enough.
same day,
Fair
within
enough.
moments.
And so, with the in moments, and then at some point the issue of recusal came up. Is that true?
That is true.
You then appeared with a hearing on December 14th of 2021 with Ms. Alexander at the initial, I guess it was treated as a 30-day status conference or some type of an initial hearing on December 14th of 2021. Is that true?
I'll take your word for it that that was the date. It was in December, and there was some question about what the hearing was.
Sure.
But there was a hearing in December.
And
Yes,
and
a
at
Zoom.
that,
I believe it was via Zoom.
at that hearing, Judge Williams raised the issue of if anyone wanted to recuse her or to have her recused from the case based upon the fact that Brandy Alexander was a Gale in her courtroom. True?
Yes.
Okay. And at that hearing, you objected to Judge Williams recusing herself on behalf of Miss Alexander. Is that a true statement, ma'am?
No, I wouldn't classify it that way. I didn't object to anything. But what I did not agree at that point. I didn't make a request for her recusal.
While you didn't, I'm not suggesting that you requested for her recusal, but when the issue of recusal came up, do you recall the petitioner's counsel requesting that Judge Williams be recused because of that relationship that Brandy Alexander had with the judge or the court at that time?
Yes, I recall petitioner's counsel raising petitioner's concerns about Judge Williams' obviously favorable view of Brandy Alexander because she was a guardian in several cases in Judge Williams' division.
Okay. And at some point, did you take a position regarding whether or not Judge Williams should recuse from the case? Do you recall that?
I recall the position at that time was that we were not seeking recusal.
Okay.
And if I may, I believe there was some conversation about the fact that Brandy Alexander had pending guardian cases in front of numerous judges, if not all of them, on the family law, in the family law division in Fulton and other metro counties.
Would taking a look at the hearings transcript refresh your recollection about what your position was back in December of 2021?
Sure.
Okay. If I can approach.
Sure.
I'm going to direct your attention to, I guess, what I'll mark as Respondents Exhibit 1
Mm-hmm.
at some point. And this is a hearing transcript. This is a transcript of the hearing of December 14, 2021. And I'm going to direct your attention to page 7. And I would ask that you read from line 14 on. Of course, you can read it in its entirety, but I mean, I'm trying to focus your attention so that we can get to the heart of the matter.
Okay.
And then extend go at line 14 and then go over to line, to the next page on page 8.
Are you asking me to read this out loud or just
No,
read it to myself?
yourself,
Okay.
and I want to ask you some questions as to whether or not it refreshes your recollection.
Okay, this is 6, 7. Yes. I said it was pointless based on the fact that if that was the grounds for recusal, then every metro judge would have to recuse, essentially.
Okay, so you did take a position on recusal, true?
Yes, that I was not seeking recusal.
Okay.
I think that's what I testified to.
Yes, ma'am.
Okay.
I just wanted to be clear.
Okay.
All right. I'd move for the admission of the Respondents Exhibit Number 1 at this time.
Okay. Any objection to R1?
No objection.
All right, it's in.
Those are my questions.
Any follow-up questions for Ms. Franklin at this time?
No, Your Honor.
Okay, so that we know, I know you mentioned Mr. Banks wanting to reserve possibly some questions. Are we excusing Ms. Franklin from her subpoena, or are we not? I mean, what are we doing with her? I don't want her to be hanging out here all day if she doesn't need to be, but.
I may plan to recall her during our case in chief, but I will make those arrangements
Okay.
with Ms. Franklin at a later time.
So we're excusing her from the investigative panel subpoena then?
Yes.
Sounds like. Okay. All right, thank you, Ms. Franklin. You're free to go. Take care.
It is my understanding that Ms. Alexander is supposed to be here momentarily, so we might be able to resolve the issue of privilege if
Okay.
she sticks around.
Okay, that's fine too. Next witness?
Director calls a Vivian Aaron. Yes.
I have a couple of questions for her before you.
I'm not going to do anything.
Judge Burleson, were you asking if Ms. Franklin was available to stick around? Is that a...
If you have a few minutes, that may help us resolve the privilege question that we had. So if you've got a few minutes, that might be helpful, and then we can just,
Okay.
that may prevent you from having to come back at all, potentially. So, yes. When is Ms. Alexander's expected in, what, 15 minutes, something like that,
She
20
should-
minutes?
This next witness is going to be on the stand for a little while, though.
Okay.
So,
Is it?
Who's lawyers are ready? They do.
Okay, yeah.
Show up.
They swear.
Yeah.
okay, yes.
Ms. Aaron, you can come forward and have a seat right here, please.
please raise your right hand. Do you swear or affirm the testimony you will give in the matter pending before the hearing panel of Judicial Qualifications Commission today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Director, I have a couple of questions of the witness before you get going. All right, good morning.
Good morning.
Are you familiar with the proceeding going on today here?
Yes, I am.
And were you under subpoena to be here at a specific time?
Yes,
And what time was that?
I believe 9 a.m.
Today?
I know it said yesterday 9 a.m.
Did you leave in a huff yesterday?
No,
Okay.
I was here all day yesterday.
And where were you this morning?
You mean after I left my house?
Yeah, were you supposed to be here at a certain time this morning?
Yeah, I believe 9 a.m.
What time did you get here?
Maybe about 7 minutes ago.
You understand this judge is on having a hearing to determine her career and her livelihood.
Yes, I do.
Is
Your Honor.
whatever you were doing more important than what she's doing?
I didn't say that.
You're a part-time judge?
I am. I was in surface traffic and then I got onto the highway and got on the highway.
You understand you're subject to the Code of Judicial Conduct, don't you?
Yes, I do.
Okay, thank you. I'm done.
Ms. Aaron, will you please state and spell both your first and your last name?
Edidiong, Edidiong. Last name is Aaron, Aaron.
Okay, and you're an attorney here in the state of Georgia, correct?
Yes,
And when were you barred? What year?
2010.
Okay. What kind of law do you practice?
Family law and a little bit of personal injury, but family law.
Okay. And you are also a part-time magistrate court judge in Clayton County, correct?
Yes,
Okay. How long have you been a part-time judge there?
since last year.
Ms. Aaron, I'm going to go ahead and address this issue now. Throughout the course of the JQC's investigation regarding the complaint in which you are a witness, continuing through service of you for this hearing, you have not been cooperative. Is that correct?
No, that's not correct.
Okay. You believe you've been cooperative?
Yes, I mean, do you want to define more of what cooperative means so that we both have the same understanding? You contacted me, came to my office initially. You and another gentleman, I opened up the door, or someone from my office opened up the door. You and I spoke. You asked me whether or not I would be wanting to be involved, and I said I didn't. And then you said that you would have to serve me, and I said okay. You gave me the subpoena, and I appeared virtually at one of the presentations. I'm not sure what it was called. Thereafter, I didn't hear from you, and I haven't heard from you since then. And last week.
So let me stop you there.
Sure.
The event you're referencing where I came to your office and spoke to you, that was in 2022, correct?
I don't recall the actual year it was. This has been so long ago, but likely so.
Okay. And during that meeting, did I ask you if you would provide an affidavit instead of having to appear in front of the investigative panel?
I don't recall you saying that, but I know that you asked me to speak to the panel. What you said was, did I want to be involved? And I said no. And I then asked you, I said, is it like a hearing and where I'd have to testify? And you said yes. And I said, I didn't want to be involved. And you said, well, then, you said it politely that you would have to subpoena me. And I said, okay. And then the guy that was sitting next to you handed me the document right on my desk.
Okay. But you don't recall prior to that me offering you the ability to complete an affidavit in lieu of having to appear?
In that same conversation, no, I don't recall that.
Okay. So you were served a subpoena and we allowed you to attend virtually based on your work schedule, correct?
Yeah, you handed me a subpoena and I'm not sure that you did that based on my work schedule. You told me that the option was to appear virtually. I wasn't at work that day, so.
And you said that you did not wish to be involved in this matter, correct?
Yes.
At the time, back in 2022, Brandy Alexander was one of your close friends.
She was a good friend.
There's a difference between good friend and close friend?
Yeah,
Okay.
there is.
What's the difference?
I think close friend is like somebody that I talk to every single day, like a best friend. My relationship with Brandy formed as colleagues. I met her in the profession. She called me tons of times about cases, like if she had questions regarding statutes, things like that. Then we talk about, I was about to have a baby, and she talked to me about kids and what it's like. And so that's how I would categorize. I mean, I wouldn't share my personal details that are, things that happen in my household with her. I think that's something like a close friend rather than a.
You wouldn't share your personal details or things that happen in your house, but you allowed her to watch your baby, correct?
She didn't. Okay. So she was with my baby for literally 2 hours. And that, I mean,
Without you there?
for an hour without me there. And one of the hours I was there, her and I, and her daughter.
Her daughter used to call you aunt, correct?
No, she didn't call me aunt. She probably said TT.
Is that short for auntie?
So let me explain that my children call their actual biological aunts and uncle aunt. I think informally for respect, you just call somebody TT, and that's how I do it. My community does it, so we just say TT because I'm not really her aunt.
Why didn't you want to be involved back in 2022?
So I'm sure. I don't know you as much, but I know that many people in the community know that I'm very quiet. I stay to myself in my own lane. I don't get involved in drama, and so it felt like lots of drama to me. But then when you told me what Brandy said that I said, and it wasn't true, then it just kind of upset me, and I really didn't want to be involved. So that's primary. I mean, it started with me just feeling like, okay, this is just a lot of drama. But then when you told me what she said that I said, and I told you that I didn't say that, that really made me feel like, no, I don't want to be involved in it. And that's, I'm sure you're going to ask me, but that's what caused the strain in my friendship with her, or good friendship with her, because I didn't appreciate her saying that.
Okay. As an officer of the court, you didn't feel as if, you're suggesting that Brandy has said something that's untrue, right?
She did.
Okay. And so as an officer of the court, at that point, once you realized that, you didn't feel like you had an obligation to cooperate or to be involved in this process?
I think that back to your first question was whether or not I have cooperated. I feel that I have cooperated. And so that's why I'm here. Did I feel like what she said was untrue, or what she said was untrue? It wasn't true. I didn't want to go, in between whatever they had going on, and so no, this wasn't my dog in the fight, or I didn't have a dog in the fight, and I found it to be messy, convoluted, and lots of untruths. So,
How do you define cooperate?
she asked me to, Miss Veal.
Okay.
She'd asked, when she came to my office, she asked me whether or not I wanted to be involved. I said no. And she said, okay, well then, I'd have to subpoena you. And I said, okay. And she handed me the document. I appeared. I came yesterday, and I waited. I came at 9 and waited the entire day. I hadn't actually even spoken with Ms. Veal. She didn't speak to me yesterday, so I wasn't sure.
How do you define the entire day? Because I was here the entire day too. Did you stay till 6?
Yeah, I was here. I walked out. Yeah, I was here till the very end. No, you all weren't. When I came in to see if I was excused, no one was here except her. This entire side was gone, and she was packing up her things. So,
Okay, thank you.
So does your definition of cooperative include evading service of a lawful subpoena?
I don't believe I was evading service.
All right, well, let's-
And so I do. So I'm aware that I have the ability to answer yes or no, and then give you a response is what I would like to do. So no, I don't believe that I evaded service. And I was about to mention it, but you stopped me to ask me another question. Last week, I think it was Thursday, your process server called my office, and he may have called Wednesday. As you are aware, I'm a litigator. I'm in court pretty much every single day, and I was in court every single day for the last several weeks. He called my office and asked my staff whether or not I was there. He said that he was from the JQC and he needed to discuss something with me. They told him that I wasn't there, which I wasn't there. I later learned that he had come to my house. I was not at home, but he come to my house and met my husband, I guess maybe on the driveway, and introduced himself to my husband. I've never seen him, and I think that this is him here. I've never seen him before. I don't know what he looks like. He came by to the house. My husband told him that he would need to leave the property because my husband wasn't aware of what he was there for. He hadn't heard about it or wasn't aware of what he was there for. And so I think that he left, but then he came back and knocked on the door again. I have a 3-year-old and a 1-year-old. And so my husband was not happy with that. He called the police and asked that he leave.
Did it offend you that he came to your home versus your office?
No, I wasn't there. I mean, so it didn't offend me in any way.
Well,
I don't
somebody
think
was
it-
offended that they called the police, though, right?
Yeah, my husband said he was banging on the door, bang, 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 bang on the door, after my husband had already told him I wasn't there. So, yeah, I'm sure he was offended. It was probably around 9:30, 10 o'clock at night. Again, I have a 3-year-old and a 1-year-old, so
You
I'm
subpoena witnesses in your practice, though, don't you?
I do.
Did your office communicate to you that he had attempted to contact you there on more than one occasion?
No, I talked to my staff on Wednesday and Thursday, and that's when I knew that he contacted me on Wednesday and Thursday. Before that day, I don't know that he contacted me.
Okay, were you aware that he went to your office as well?
Ms. Veal, can we get to the charges? I mean,
Well,
is this relevant to something that is in the charges?
I think it is relevant to her credibility that you all are going to have to weigh.
Okay, I think we've gotten the flavor for what happened. I'd want to get into the substance of the charges, please.
So if I am not going to be permitted to ask her follow-up questions,
I'm not. If you want to ask her what you need to ask her. But I really am more concerned with the substance of the factual allegations at this point.
okay. Where were you at 9:30, 10 o'clock at night if you weren't at home?
Out with friends. I have, again, a 1 and a 3-year-old. It was my first time actually being out in 3 years without my children or my husband. So,
Okay. But your car was at the house?
yes.
Okay. Did either your dad or your husband inform you that when Investigator McFarland spoke to either one of them, he identified himself and let them know that he was there to serve you a subpoena?
My dad doesn't live there, but
Who was the older gentleman that first answered the door?
likely my husband's father, he came into town.
Okay.
Yeah. And
So-
so, no, he didn't. But my husband told me that somebody said that they were coming from the JQC to speak to me. My husband's not an attorney, so he's not going to properly use legal terminology. He said that somebody came to speak to me, and he told my husband that he was there to speak with me. My husband told him that, he doesn't know anything about why he would be here.
Okay. You testified that your husband called the police. Did you know that he called in someone who had identified them as a state investigator, that he called them in as a suspicious person and then refused to meet with the police?
I wouldn't know that. I wasn't there.
Okay. The following morning, after Investigator McFarland had come to your house, he then went to your law office, correct?
So, yes, he did. I later came to learn that was him. So every morning, or typically every morning, I get up pretty early. It was around 7 something in the morning. I went to my office to drop my things off, and then I was going to go ahead to go work out. A man which I later learned was Mr. McFarland, in a old car. I can't describe what kind of car it was, but a big car that looked like a kidnapper vehicle, swerved his car as I was already in my car about to leave out, swerved his car perpendicular to my car, and it looked like he was attempting to get out. I drove off. I had not, he actually scared the mess out of me. I drove off, made a right onto Jonesboro Road, and then turned on to Battle Creek to head to the gym. It wasn't until I got further down on Battle Creek that I realized that his car was still following me. I called my husband and told my husband that somebody was following me. And I think it's important to also know that I keep security at my front door, meaning you can't just open up my front door, and that's because as a family law attorney, I've had opposing parties try to come to my office. Hold on one second. Try to come to my office, and so once I realized he was still following me, I called my husband and said somebody was following me. I left him a voice message because he didn't answer, and I kept driving. Finally, my husband got into the car, heard my voicemail, and called me back. And I explained to him that there was a white gentleman, bald head. He looked tall because he was almost as tall as the top of the car, and it was a big car, that somebody was following me. And my husband said, that's the guy who came yesterday. I then called Mr. McFarland from my Nextiva phone app, and I called him twice. Once I realized it was him, he did not answer. So I called my husband back, and I told my husband my husband told me that he was back inside of the neighborhood, waiting at the neighborhood. My husband came back into the neighborhood. And I told my husband to tell him that he can meet me at the office to serve me, which is what my husband said. He stopped, spoke to Mr. McFarland and told him that, and then Mr. McFarland met me back at the office. I pulled in and opened up the window, and he handed me the subpoena.
And when he handed you the subpoena, he advised you to...
What's your objection?
For relevance, the panel has let this go on and on. Ms. Aaron is not on trial here. It's been more than 15 minutes.
Well, I think I overrule the objection to relevance, given that this does go to credibility and bias, but I take your point that, as Mr. Lopez has already pointed out, I think we are clear she does not want to be here, that she did not readily accept a subpoena. We understand her explanations. So the objection's overruled, but I do think we got it.
I'll move on. Ms. Aaron, let me direct your attention to February 8th of 2022 and the phone call between you and Judge Williams that you and I have previously spoken about and that you testified in front of the investigative panel about. Do you know the call I'm talking about, I'm referencing?
Yes, I'm aware of the call.
Okay.
I don't know the exact date, but yes, I'm aware of the phone call.
Okay. Why did you have that phone call with Judge Williams on that date? What prompted it?
I told her, I said, hey, give me a call. And that was like earlier in the day. She then called me kind of late in the evening. We were just talking. I had just had a baby. I was, postpartum. I'd been before her. I'd taken a pretty long leave. And so it was a casual conversation, a casual phone call.
Okay. So you said you had reached out earlier in the day to her?
I did.
How did you reach out to her?
I believe via Zoom.
Okay. So why were you on a Zoom with Judge Williams?
I was in court.
On a case that you had pending before her?
Yes.
Okay. And so how did you communicate with her on the Zoom?
Zoom has a chat feature.
Okay, so what did you send her in the chat?
Hey, how are you? Give me a call.
And that was in the middle of your hearing before her?
My case was done. We didn't actually have a hearing. It was a status conference. I believe the guardian had already given her or spoken. It was like a status conference, so it wasn't a full hearing, if you're aware of what status conference.
Okay. Did she respond to your message?
No, I don't believe that she responded at the moment. I can't recall because I got off the Zoom call. But I mean, obviously she saw it because I did speak with her.
Okay. And you said it was much later in the day?
Yeah, it was. I know it was, I don't know what time it was, but I know it was late because I can pinpoint that I was holding my baby and she was about to sleep.
Okay. Do you recall that you told her that you had reached out to laugh with her about the crazy case that you had before her?
I don't recall that, but that's possible. That case was a silly case.
All right. Would it help to review your prior testimony that you gave before the IP in recalling whether or not you told her that you had reached out to talk to her about the case you had before her?
Sure.
Okay. May I approach?
You may.
Okay. Okay.
Has your recollection been refreshed regarding what you told Judge Williams about why you had contacted her on the Zoom chat?
Yes, it indicates that I said that I was calling to talk to her about, to laugh with her about a crazy case, but I'm not going to rope her into the craziness.
So you called her first. She didn't call you. You initiated the contact.
I didn't call her. We were in a Zoom chat.
Gotcha.
Yes.
But you had called to laugh with her about the case that you had pending before her.
I had called. That's your question. I didn't call.
Okay. So when you read back through your prior testimony, did you say, I was calling to laugh with you about this crazy case?
Yes, but I didn't call, so
Okay.
yes.
So, but you had reached out to her on the chat to laugh with her about the crazy case?
Yes.
Okay. Did you all talk about your crazy case?
No, because I said, if you read back again what I said, I didn't want to rope her into the craziness of the case. So that's why I said the conversation on the phone with her was very casual. I had talked about just having a baby, whatever the struggles were with that and other topics.
Okay. Did Judge Williams at that point share with you something that she characterizes, oh, I have a crazy situation as well going on?
So we were talking about, I'm in a sorority, and she is also in not the same sorority. And we were, again, the conversation was casual. I was talking about sorority life, one of my sorority sisters. And then she said, yeah, she had something going on as well, with a crazy situation, with, I believe, somebody from her sorority.
Okay, and how did she describe that crazy situation to you?
She said that somebody was trying to say things about her that weren't true, that they had filed, or there was a recusal on the table, or and that they were roping in other members of her sorority, or there was somebody else, I believe, that was also an attorney that is in the same sorority as her, and they were making statements about her that weren't true. And she told me it was, it was a family law case.
Okay, did she identify the person to you by name that she was claiming had said things about her that weren't true?
No.
Okay, did she tell you that that person was somebody that she had recommended cases to?
Yes, that she, they were gall cases, yeah, that she appointed for gall cases. I don't know, recommended, but.
Did she talk to you about a conversation that she had with that person about their request for a senior judge?
No, she didn't say that.
Okay. Would it help to refresh your recollection on that issue if you were able to review
Sure.
your prior testimony?
Eight.
Page 8, line 12.
Okay.
Has your recollection been refreshed regarding whether Judge Williams spoke to you about the conversation with that person and them wanting a senior judge on the case?
Yes.
Okay, what did she say to you?
That they wanted a senior judge. That the person wanted a senior judge.
Okay, and did she also say to you that that person wanted her to get off the case?
Can I see it again so can I keep it, or that way I can remember what?
Actually, let's just, if you could read lines 12 through 19.
Okay. I said, oh, what happened? Then she said that, I had a conversation with the person. The person wanted me to get off the case and use a senior judge, and they wanted me to get off the case. So I called them, and then it has 2 hyphens. I called them and asked them, well, hey, what's going on? Is it that you're embarrassed? I'm sorry, did you want me to go to where? 19? There is no reason for you to be embarrassed.
I'm going to go ahead and ask at this point. I think there may be several times where I'm needing to refresh her recollection. And eventually I'm probably going to move to admit this entire transcript. Would the hearing panel like a copy of it now?
Yes,
I would.
yes. Thank you.
While she's doing that, Judge Aaron, have you been
can just tell me
notified
a
by
date.
anyone with the investigative panel about the ex parte contact with Judge Williams that you initiated?
I'm sorry, I didn't hear you.
The ex parte contact that you initiated, you told us about with Judge Williams. Do you know if there's a complaint pending on you about that by the commission investigative panel?
No. And so, one, this conversation occurred, I think she said in 2022. I did not get on the bench until 2024.
Okay.
So,
Thank
no.
you.
So you marked this as P7, but I also have a P7, which was Miss Alexander's. So we want to call this one P8?
I'm sorry,
or-
Judge. It should be 8.
I just want 8, okay.
Yeah.
And are you formally admitting it at this point, tendering it?
Yes, Your Honor.
Any objection to that, Mr. Banks, Ms. McFadden?
If it's the entire transcript of both.
It appears-
Vivian Aaron and Brandy Alexander.
Well, this P7 is just Miss, yeah,
It
Miss
is
Aaron,
mine.
it is.
Is
It's
it?
Miss Aaron and Alexander is what it shows.
Mine ends at page 18, though. Is that
But
you?
then we have
But the Alexander one,
the other half.
right, we split them up.
Yeah. Okay.
But it's
So
in its entirety, they're just split between.
P7 is Miss Alexander's half of it, and P8 is now Miss Aaron's half of it, looks like.
Yes. The entire Alexander.
She just
And
passed
then
it to you earlier.
P8 is the entire Aaron, so it's that.
It's probably over there that you were
No, I
writing.
didn't like that.
All right, then no objection then, since we know it's being tendered in 2 parts, is that right? It's in.
All right, you testified that Judge Williams never identified the person that she was speaking about by name, but at some point during that conversation, you realized that she was talking about Brandy,
Yes.
right? And how did you know she was talking about Brandy?
I knew probably right after she said something about the senior judge, using a senior judge. I mean, it made sense that that's who she was talking about, or I could infer that.
And that was because you and Brandy had spoken about her case, correct?
Yes, Brandy and I.
Okay. And you said that you mentioned the motion to recuse earlier. Did Judge Williams comment to you about her feelings on the motion to recuse?
Yes, to the extent that she said that there were statements in there that were untrue. I asked, well, why don't you just recuse? I mean, I think at that time I didn't know what all goes into recusal. So I just said, well, why don't you recuse and just be done with it, And she said because there were statements in there that weren't true about her. And that's why she didn't want to recuse, that it would make it look like she had done something wrong.
And did she also express to you that, on the heels of, it would make me look as if I had done something wrong and I wouldn't want that or this to impact me in a future election?
I don't recall that, but if I mean, can you show me something where I said that?
Sure. All right, I'm on page 11, and I'm going to have her start on line 14 and read through 23.
Okay. Did you read it out loud?
note.
Okay.
Page
11.
11, starting at line 14.
Okay. No, keep this off. If you ask me again, I can.
Do you, Jamal, who's handling this witness? Do you have an objection to her having a copy of this, of the transcript? Okay. Ms. Aaron asked for a copy of the transcript with her on the witness stand, so I'm going to provide her a copy.
Okay.
Right. Did that refresh your recollection about what Judge Williams said regarding the potential impact on a future election?
Yes.
All right, and what did she say?
People start looking up, when they're running for reelection, people start looking up information, and if they see that she was asked to recuse, then they would think that she'd done something wrong, and they would look that up and may have a negative impact on her election if she ran for election.
Okay. Did she make a statement to you regarding whether, or regarding the fact that she thought that the person that had filed the motion to recuse must think that Judge Williams, was going to rule against her?
I'm sorry, I was still reading I'm sorry,
It's
tell me
okay.
again.
Did Judge Williams make a statement to you regarding the fact that the person that had filed the motion to recuse must have thought that Judge Williams was going to rule against her in her case?
Not how you said it, but and not in the same stream as coming off of something about the recusal. So she talks about the fact that they had a hearing, and that person must have felt like that it wasn't going to go in her way or go in her direction, and she thinks that that's why she filed the recusal, but that person didn't know actually what was going to happen in the case at all. That's what she said.
Do you remember her saying that that person could have just called her instead of filing the motion to recuse?
No, I don't recall that.
Did you tell Miss Alexander that, or anything similar to that?
That
The judge said if she thought I was going to rule against her, she should have just called me.
no.
Okay. All right, did you guys discuss generally child custody cases?
We did, because I frankly just said what, people say, that she's a father-friendly judge. And I asked her, I said, people say you're a father-friendly judge, what's your perspective on that? And she said that, she's heard that people say that, but she's not a father-friendly judge. And she talked about the fact that she's the child's judge. And, you know, because neither parent is, you know, one parent doesn't have more of a priority than the other parent. And so she wants people to whichever party to get her away from, if they're both on equal playing field, she wants them to get whichever person to get her away from whichever position each person is taking. So whoever it is that wants custody, she needs to know basically how you are more entitled to custody than the other person.
Okay. I'm sorry. What was your response to that?
I didn't really say anything other than, you know, I think maybe I talked about what 1993 says, and we kind of went on a back and forth banter about that the statute does talk about the fact that both parties, neither parent has a priority to custody or is automatically entitled to custody. I think we even talked about, you know, the Solomonic task and authority line with the court. I do recall we went back and forth about the statute. And she went on to explain that, you know, she's not a father-friendly judge. She wants people to walk her away from either position.
Did Judge Williams say to you during that conversation either that the parties had made it personal, or that they had, I'm sorry, did she say during that conversation that the parties had made things personal by filing that motion to recuse her?
She said she didn't know why the person was taking it personal. And that came from her saying something about that there was other people, I guess maybe that were listed in the recusal that they both equally knew. I have not seen what I don't know what the motion for recusal looks like. I haven't seen it. So I don't know who the other person was that she was referring to. But I mean, again, I knew that she was talking about Brandy. I just didn't know what all other players were being named in the recusal or why they were, you know, in the recusal. I don't know.
Okay. Did Judge Williams, during your conversation, at any point say to you that she was going to show the person that had filed the motion to recuse personal and was going to take the child and give the child to the father?
No,
Okay.
not at all.
Did you tell Brandy Alexander that Judge Williams said that?
No, I didn't. That's what I was referencing this morning, that is the piece that why our friendship is no more, because I didn't say that. And Brandy knows that I didn't say that. And that was a large part of our discussion, my discussion with Brandy, when we did speak long ago, that I didn't say that. What I told Brandy, specifically when Judge Williams said that, you know, that this person doesn't know what the outcome of the case is going to be, I explained to Brandy a similar story about a judge in Cobb County that, you know, I felt like the custody case was not going my way. Judge, you know, was overruling all of my objections, sustaining the other person's objection. But then by the end, the judge awarded my client custody. This is the exact story I shared with Brandy. And listen, I understand people get, you know, emotional about their kids. And from what I know of Brandy, I know how serious she is about her one child, and the circumstances with the child's father. I get that. But I think at a certain point, Ration departed from Brandy, and there wasn't a way to calm her down or make her understand that what you're perceiving, even if you're just perceiving that this one hearing, this temporary hearing went bad, which it wasn't like, from her telling me the story, it wasn't like the judge had changed custody at that time or anything. She felt like the hearing had gone bad, and she became another Brandy. Like, I mean, and I'm not saying, I understand that people feel how they feel about their kids. I get that. What I'm just saying is that there was nothing that you could have said to Brandy to calm her down, to make her think anything other than, that Judge Williams was going to, take her child, or, dad was going to get custody.
So did you say anything similar to that?
Absolutely not.
Did you comment at all on Judge Williams said this was what she was going to do in your case? I'm just trying to figure out, was there anything that you said that she could have taken from
No,
that?
no,
Okay.
Ms. Bill.
Okay. I'm sorry. Is there something else?
No, I was just going to say, Judge Williams didn't tell me that she was going to do anything in the case. What she was saying was that Brandy thinks that, based on whatever happened in the temporary hearing, that maybe the case was not going her way. But she doesn't know what's going to happen in the case. This is what I explained to Brandy, which is why I gave her the story about, Judge in Cobb County, to like help her relate that, okay, it could be okay. Like, I think maybe the part that we're missing is that Brandy also, plenty of people thought that she's a dad's judge or dad's friendly. You've got judges that are mom friendly judges, where that this judge, no matter what, is going to say, hey, I think all kids should be with moms. And so in Brandy's mind, if there's a judge that's a dad friendly judge, and she initially asked for a senior judge to hear the case because she's afraid that maybe it won't go her way, but then somehow she still stays on the case and is, she doesn't feel like the temporary hearing went her way. Yes, she's going to think that, oh my gosh, this whole thing is going to go horribly and dad is going to get custody. And that's what we're not talking about, is that was the biggest concern for her, is dad getting custody.
Okay. So while you were on the phone with Judge Williams, you text Brandy to tell her Judge Williams has called me and is talking to me about your case.
Yes.
Correct?
Mhm.
So you told
That's
Brandy while you were on the phone with
I was
Judge
like,
Williams.
yes.
Okay. That the judge has called me and she's talking about your case.
Yeah.
Okay. And then you and Brandy spoke on the telephone the following day, correct?
Yes, or the next day. Maybe either the next day or the day after.
Okay, and you shared that Brandy had obviously told you that she was worried about what was going to happen in this case.
Yes, Brandy had previously told me that her and Judge Williams had a phone call. She told me about that. And I don't know what in that phone call made her feel confident or feel good, but she felt good about Judge Williams being on the case. But then after
the phone call they had, she felt good, like, this is going to be okay. This is going to be good for me.
Yeah, she was just like, I'm not, worried about it or whatever. And then they had the temporary hearing, and then Brandy wasn't okay. And then it became that she wanted her to recuse.
Okay. Were you aware at the time you had the conversation? I'm sorry. I'll withdraw that. Did Brandy, after you and she spoke on the phone, did she ask you to fill out an affidavit?
I don't recall that. She told me that you all would want me to testify, or that I think maybe her attorney asked, would I testify? And I'm not sure if that was Catherine or William, but.
Okay, and is it possible that she said, hey, my attorney would like for you to do an affidavit?
I am pretty positive she said that they would want me to testify, because we were on a phone call when she asked me.
Okay, look at page 17, line 17 through line 23.
Okay.
Okay. Does that refresh your recollection?
Yes.
Okay. And what did you tell her about doing an affidavit?
No. Will you do it? I told her no.
Okay, and that was, for the reasons that you said earlier, that it was messy and you didn't want to be involved?
Yes.
How long did
And
you-
barring at that,
Go ahead, I'm sorry.
and at the time in which she said that she'd asked me that William wanted to talk to me, I didn't know that she said that piece like, oh, Judge Williams is going to take my baby away, or it's that she's going to make it personal and take my baby away. It was Judge Williams who said she doesn't know why Brandy is taking it personal. But at this point, I didn't even know, because again, me and Brandy we were still talking. I didn't realize that that's what she had said, that I said she's going to take it, or that Judge Williams is going to take it personal and take her baby away. At this point, I just didn't want to be involved because I just felt like it was messy. But then I really didn't want to be involved once I learned that that's what she said I said. And then,
You answered it, thank you.
okay.
But when I met with you in 2022, I told you, I specifically asked you about that statement. Judge Williams, did she say that she was going to take the child?
You possibly said that. I don't recall that you said it at that time, but you possibly said that. Because I think that I would have, again, after you left my office, I can't say with certainty that you said that she said that, because I was still talking to Brandy after that. Once I learned that she said that I said she was going to take her baby away, I called Brandy and asked her, why did you say it? We had a lot of conversation, and that was the end.
How long have you known her?
Brandy?
You may have answered and I missed it.
I didn't mention it. I believe I met Brandy in, it could have possibly been 2017.
What's her reputation?
As far as what?
Would you believe her under oath?
Brandy, I think that Brandy, okay, so if you would ask Brandy, hey, did you say da-da-da-da, she'll say, I don't remember saying it. So I will say that Brandy doesn't have good memory, even if you ask her something from 2 weeks ago.
Okay, thank you.
But I'm not going to say.
If I could have just a moment. Sure.
Right, Ms. Aaron, that's all I have at this time.
Any questions on behalf of the respondent?
Yes.
Good morning, Miss Aaron.
Good morning.
We met briefly in the hall yesterday, but we hadn't met before that. Is that right?
Correct.
Let me start by clearing something up. Director Veal asked you about the reason for your call to Judge Williams, the chat to Judge Williams. Right?
Yes.
Okay. And you looked at the transcript. Can you look at that transcript again? On page 7.
Okay.
Starting at line page 17. Can you read that into the record, starting with the complete sentence?
Hey, this is, she said, hey, this is Shermela. I said, oh, hey. She was like, I got your chat message. Wait, how far do you want me to go down?
Keep going, please.
Got your chat message. What's up? Wait, I'm sorry. What's up? Okay, she was saying, what's up? I was like, I was calling to laugh with you about this crazy case, and then I said, but I'm not going to rope you into the craziness of the case. So
Okay.
she said.
Thank you.
Okay.
So you didn't tell Judge Williams that you were calling to talk about a case that you had in front of her? Is that
No,
accurate?
not when I chatted her, no. Is that what you're asking?
Both.
Correct.
And when you talked to her, you didn't tell her that you were calling to talk to Judge Williams about a case she had before her. Is that right?
Can you ask me the question again?
In the transcript, it doesn't say that you were calling Judge Williams to talk about. You don't say that you were calling Judge Williams to talk about a case that you had in front of her. Is that right?
Correct. I said I was calling to laugh with you about this crazy case.
Okay. Do you know if Judge Williams has her staff checking the chat messages?
Yes, I know that to be true.
Okay. And you said Judge Williams didn't respond to the chat message, right?
She didn't.
Okay. So is it possible that one of Judge Williams' staff members could have checked the chat message and gave the message to Judge Williams?
That's possible. I mean, yeah.
Commissioner Hyde asked you if you would, if you thought that Ms. Alexander would be truthful under oath or something to that effect, right?
Yes.
Well, you know, Ms. Alexander has told at least one lie about you, something that you said, right?
Yes.
Say more about that. What is the lie that Ms. Alexander said?
And let me start off by saying too, I also have not fully read all of the charges in the complaint because it was a lot. And so the moment that I got, first of all, I didn't even know that the complaint had come out, right? And somebody messaged me and asked me, "Are you EA?" And then I went to go and check it, and I started reading it. And once I saw the lie, I didn't read any further past that. But what she said was that I told Brandy that Judge Williams said that they're taking it personal, and I'm going to show her personal, and I'm going to take her baby away. That is the lie. And to be quite honest, you know, if I'm on the phone with Judge Williams and she says that or is bold enough to say she's going to take this person's baby away, I mean, honestly, I think that I would have been like, I would have had a very pointed discussion with her about how are you going to take this person's baby away? But that didn't occur. I mean, it's not as if I was afraid to say to her, hey, people think that you're a father-friendly judge. Let's talk about it. I think that would just be a really bold statement for her to make, that she's going to take somebody's baby away. And like Ms. Beal said, that I texted Brandy on the phone and said, hey, I was on the phone with Judge Williams. If she had said that on the phone, I would have said in text, girl, she's trying to say she's going to take your baby away. Like, I feel like we would have probably rallied the troops on that. That's just not something that, again, I understand her love for her daughter. And if that is what Judge Williams would have said, I probably would have put my foot down too, and yes, would have been like, no, she did say blah, 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 and you guys need to do something about it.
And that lie that Judge Williams had said she would give custody to the father, that made its way to the complaint. Is that right?
Yes, it was in the complaint.
Okay. And did you tell Director Veal or anyone from the, not Director Veal specifically, but the investigative panel that you had not said that?
You mean when I was called to testify that day?
Yes.
I don't recall if that was asked of me that day, but I do know I told Director Veal that I didn't say that. She asked me about it, and so I did tell her that if it was asked of me at that panel that day, I'm sure I would have also told them too. I didn't say that.
Let's take a look at page 14 of the transcript, near the bottom. And let's start at line 21, and I'd like you to read it out loud, please.
Ms. Veal, or this is Ms. Veal speaking. Okay, did she tell you what decision she was going to make in Brandy's case? Ms. Aaron, no. Ms. Veal, okay, did she tell you that she was going to show the parties personal because they had made it personal? Ms. Aaron, no. Did she talk anything about giving the father more visitation or giving the father custody? No, she didn't.
Okay.
But no, she didn't. But Brandy felt that way. And Brandy did feel that way.
Let me,
You-
oh, go ahead, I'm sorry.
What also needs to, I mean, I don't know if it's relevant, but at the time in which this custody case was going on, well, at all times before this, Dad lived in another state. So there wasn't a big concern about potentially Dad getting custody or Dad having more parenting time or whatever. But then Dad moved here to this state. And so the idea of him having more parenting time became more real to Brandy. And that's what he was asking for, more parenting time.
So Director Veal asked you specifically, did Brandy tell you whether she was going to show the parties personal because she made it personal, and you said no?
Yes, that's correct. No, she did not say that.
And I'm sorry, I misstated the question. Let me say it again for clarity.
Okay?
Director Veal told you that you told Director Veal that Judge Williams, I'm confusing myself now.
Yeah.
Hold on a second. With all the she's. Ms. Veal asked you whether Judge Williams told you that she was going to show the parties personal because they had made it personal. And you told Director Veal that you had not said that, right?
Correct. I didn't say that.
Let me ask you about the formal charges. May I approach?
You may.
I'm showing you the formal charges that have been filed in the case. I know you said you didn't read them.
You want me to
in
fully
their
read it
entirety. No,
Oh.
I want to direct you to a specific
Okay.
paragraph. I wouldn't ask you to read all of them.
Okay.
You can take that one.
Okay.
Second one, show.
She's gonna tell us in just a minute. I'm guessing 40.
I was asking you, Ms. Aaron, about paragraph 42.
The facts are on the front. That's the case.
Is that the paragraph that you're referring to when you said that wasn't true?
Correct.
And you had told the JQC that wasn't true?
Correct.
And then it made its way into the complaint?
That's right.
And that upset you?
Yes.
Was there anything else that you noticed from the complaint that wasn't true?
And also told respondent that Judge Williams said that in 41, also told respondent that Judge Williams said the respondent and her attorneys had made it personal. That's not what she said. She said that she didn't understand why the person was taking it personal. She was talking about Brandy.
So let's make that
Oh,
clear.
and then 43, she didn't say that she had given her a lot of business. Okay, so Brandy is also a guardian ad litem. And by appointment, a judge has to appoint the guardian ad litem. And so she said that she's been a guardian ad litem for her, that she's been appointed as, several cases. She didn't say that those weren't her words, that she had given a lot of business. And also, she didn't say she should have just called me, meaning Judge Williams, instead of filing a motion to recuse. She didn't say that.
Okay. Did you tell the JQC that Judge Williams had not said that?
I don't recall them asking me about, she should have just called me instead of filing a motion, and other than when, I guess maybe Ms. Beal asked me, I think, in here.
Do you mean the investigative panel?
The investigative panel?
Yes.
Yes. I'm sorry about that.
I'm sorry.
Picky.
You all had asked me, or,
It's not us.
okay.
Not us.
We won't get into the details of it, but there are two there's an investigative panel and the hearing panel.
Okay, where I
You
was
were-
on the Zoom.
Yes, that was the investigative panel, not the hearing
judges.
panel. Yes.
Okay. Okay. Yes, correct. That, so what I'm saying is, I believe that I was asked that by the investigative panel as well. But I am telling you, no then, I said no then, and I'm saying no now. She didn't say that.
She being Judge
Judge
Williams did not say
Excuse me.
that.
Judge Williams did not say that.
And you didn't tell Miss Alexander
And I
that
did
she
not-
did say that.
Correct. I did not tell Ms. Alexander that she said that.
Why do you think Miss Alexander would make something up, say something that you said something that you actually didn't say?
One of the things that I've heard in practice is that with criminal litigants, they are bad people on their best behavior in their cases. And in family law cases, you really get good people that are on, that on their worst behavior. When we deal with family law cases, it is really heightened because people care about their money, their assets, their children. Those are three things that people care greatly about. And if anybody has ever had family law cases, a witness will get on the stand and say something that, is completely untrue, and then the other party is jumping around like, no, that didn't happen, because each party is trying to proffer their side as if this is really what happened when it didn't happen. If Brandy didn't feel good about the temporary hearing, which she didn't feel good about, she didn't. She was, in fact, crying. She was, inconsolable. No matter how calm I was trying to talk to her, her other, I guess, friends were trying to talk to her too. I mean, her and I were on the phone separately. But no matter how calm I was trying to get her, she, like I said, reason and ration departed from Brandy. Why she would tell a lie on me, I don't know. Or maybe, again, I understand she has a child. She wants to protect that child. So while I can't speculate to why she would say that about me, I can assure you that her love for her child runs far deeper than her friendship with me.
Do you think that Miss Alexander's love for her child would cause her to tell a lie about Judge Williams?
Absolutely. Because that is the lie.
Do you have an opinion about Judge Williams personally? What do you think of her?
I don't have any opinion about her personally. I know her I've never gone out to eat with her. I have not gone out we don't hang out. We're not in the same sorority. I don't think anything negatively about her. I don't know her deep enough to say, oh, she's this or that. I know Brandy. I knew Brandy.
How about professionally? Do you have an opinion about Judge Williams professionally?
Sure. I've had several cases in front of her. She has a really good memory. I'll say that. She has, the memory of an elephant. You can have a case with her and let's just say we're at a status conference and then we come back for another hearing. She would have remembered all of the facts of the case. I don't know if that is attributed to her, maybe her reviewing the file. I don't know. But I know that she'll be like, no, yeah, I recall on this day, da, 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 da. Her memory was really, really good. I can't personally say that she was ugly or mean or rude to me on the bench. I've always had positive experiences, even if the case wasn't decided in my favor. I mean, that's no problem, but I mean, that's what is to be expected. You don't get the best cases all the time, but
Okay. Anything else?
no.
I just wanted to make sure I wasn't cutting you off. Let me go back to the conversation you had with Judge Williams to just clarify a couple of things. You mentioned that during the call with her being Judge Williams, she didn't mention Brandy by name, right?
Correct.
And she didn't mention whether she was even talking about a male or female, right?
I think at some point she said she, but the majority of the conversation she said this person, or she referred to him as this person. But I mean, I'm pretty positive that at some point she may have said she. I mean, she would have had to say she because I knew that they were in the same sorority. So.
Judge Williams didn't ask you your opinion or advice about the case, did she?
No.
And we've already gone over the fact that Judge Williams didn't tell you anything about the way she would rule in that case.
Correct.
Now, you mentioned that Miss Alexander, and I've referred to her interchangeably as Brandy and Miss Alexander. You understand that, and I'm not trying to be disrespectful or rude in that. You mentioned that she was in she had a contentious relationship with the father of her child.
Very.
Why do you say that?
It was. They have had. Again, I'm not trying to be. I'm not trying to be messy or anything. They've had a contentious relationship. They've had lots of litigation. And they just don't have a good relationship.
What are some of the areas of contention? For
The
example?
only area is Cadence. Is her daughter? Excuse me.
Was Miss Williams upset about
Miss Williams?
I'm sorry. Was Miss Alexander upset about the father moving on with another relationship?
Yes.
I'm going to object at this time. Ms. Alexander is going to come testify, so I think those questions should be asked of her and not a former friend she may have talked to.
Some of this might go to credibility.
Maybe, although I don't want to let the sideshow of what's going on with Miss Alexander's custody dispute with her husband or ex-husband or father of her child sort of take over what we're doing here. So I'm giving you a little leeway, but I'm straining to see a whole lot of relevance in going too deep in whatever that situation is, to be honest with you. But I do think maybe the better person to answer these questions is Miss Alexander. So in as much as there was an objection, I would sustain the objection. I guess you would only know it because Miss Alexander
Correct.
confided it in you,
Yes.
correct, and told it to you.
Yes.
Understood. Let me ask you about senior judges. And there was a conversation about Miss Alexander asking about a senior judge.
Yes.
You recall that? Are you aware that senior judges only hear certain aspects of a case and not the entire case? At least in the Fulton County Superior Court Family Law Division?
That's not my understanding of it, but I could be wrong. When I think of a senior judge, I've had cases where, let's just say, the sitting judge is not available, or, maybe they work something out amongst themselves, and the day you show up at court, a senior judge is hearing the case. And And so that might be a scheduling issue, but I don't know how they decide that. But I have had a senior judge hear my cases before. There are judges that do that in every county.
So in Fulton County Superior Court, was that the example you just gave where you
No,
showed up?
it was in Henry County.
Okay.
So have I ever had a senior judge hear a case in Fulton? Is that
Well, not preside over hearing, but have the entire case.
No, I've never had that happen. I've had, if the parties agree, you can have a judicial officer hear it. Like they will hear all of the status conferences, and if you, by agreement, you can agree that they will hear the final hearing because they've been with you they've been with the parties throughout the whole case.
In your family law practice, well, let me scratch that and make sure something is clear for the record. When Ms. Alexander told you about her call with Judge Williams, did she ever tell you that Judge Williams talked about the merits or substance of the case with her?
No, she told me that they didn't talk about the merits. Brandy told me that they didn't talk about like the substance of her case. She'd asked her. Brandy told me, and Judge Williams confirmed it in my call with Judge Williams that she'd asked her, hey, are you embarrassed? You don't have anything to be embarrassed about. I hear cases all the time.
But nothing about the substance?
No, nothing about the substance.
Excuse me, 1 second, I might be wrapping up here.
Okay.
That's all I have.
Anything further from Ms. Aaron, Ms. Field? No, Your Honor. All right, and so we are clear, and our record's clear, and Ms. Aaron's instructions are clear. Is she now excused from her subpoena, or is she just free to leave but still under subpoena and has to come back if called to do so?
She is excused from my subpoena. I don't know if she's under subpoena by the respondent.
Nope. So
She is not.
She's free to leave and does not have to come back.
Correct.
Thank you. You're excused. All right.
Thank you, Ms. Aaron.
Why don't we go ahead and take a 10-minute recess before we swap witnesses? So we'll be in recess for 10 minutes for a comfort break, and then we'll start back. If you all need a little extra time, just grab Mr. Parmar and tell him. I know y'all said you were going to try to talk with Ms. Franklin and Ms. Alexander while they were maybe both here to resolve that issue. So if you need more time, just let him know. We'll be glad to delay a few more minutes.
Thank you.
All right, and that's correct, Ms. McFadden, no objection to the amended local rules.
No objection.
All right, so they're in without objection then.
And for scheduling purposes, how late are we going to go this afternoon?
Well, I mean, obviously, I don't know that we want to stay till 8 o'clock, but I'm also, if we need to accommodate a witness, that's okay too. What are you think? Tell me what you're thinking. What do you have left?
So I have several witnesses left, not several that are all going to be long, but yesterday we were informed that this building closes at 4:30, and is that not a?
It
Okay.
closes when y'all are done with it. Don't worry about that.
Don't worry about that part.
Okay. Yeah, I mean, I definitely have witnesses that could take us through 5 or 5:30.
I think that's fine. You
Okay.
good with that?
Yep.
Okay, we're good with that.
Okay.
All right, then if you will please call your next witness.
Director calls Dawn Smith.
What about that last night, right? And it, yeah. 'Cause I kept thinking, that doesn't sound quite right, but I know exactly what's going on. Yeah.
Great. Ms. Smith, if you would raise your right hand, do you swear or affirm the testimony will give in the matter pending before the hearing panel of the Judicial Qualifications Commission will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Smith, if you could please introduce yourself and spell just your first name for the record.
My name is Dawn Smith, D-A-W-N.
And Ms. Smith, you are an attorney here in Georgia.
Yes.
How long have you been practicing?
So I was barred in 1989. I'm old.
All right. What kind of law do you currently practice?
So I'm a family lawyer.
Okay. How long have you been a family lawyer?
Well, for roughly 36 years. So I've always done things involving children.
Okay. Want to talk to you about an incident or something that occurred back on October 18th of 2021. At that time was an attorney by the name of Brandy Alexander renting office space from you.
Yes, I have a building in the North Lake area, and she was renting a small suite from me.
Okay. How long did she rent office space from you?
From roughly 2020, I went back and looked at the leases, until 2023,
Okay.
or the end of 2022.
How well do you know Miss Alexander?
So at the time, I knew her pretty well, and I still know her pretty well. I mean, I trained her to be a guardian ad litem when I was deputy director of Atlanta Volunteer Lawyers Foundation. And so that's how I met her. And then we kind of had a mentor-mentee relationship. And then when she moved in, I kind of served as, a senior friend.
Okay. Is Brandy somebody, or Miss Alexander somebody that you would believe if they testified under oath?
Yes, I would.
Back on October 18th of 2021, were you and Brandy both in your office that day?
So I was on the main office floor, which is the second floor of my building, and Brandy was speaking with my associate, Tammy Brady, and I was in my office, but we are all on the same floor.
Okay. At some point, did Brandy come into your office?
Yes, it was about mid-afternoon, sometime in the afternoon, and she came in flustered, holding the phone on mute,
When you say the phone, was that her?
her cell phone.
Okay. And did she say anything to you?
She said, this is an approximation, "Oh my God, Judge Williams just called me on my cell phone, I need a witness."
Okay. What did she do after she made that statement?
So she sat down in the seat right across from my desk and proceeded to have a conversation with Judge Williams.
And you said the call was on speakerphone.
It was on speakerphone.
Okay. Tell us what of that conversation you overheard to the best of your recollection today.
So as she was coming in, it was right as she was coming in, I heard that my judicial assistant said, I might not should call you, it's an ex parte conversation, but I told her we're sorors. And then she proceeded to say, I know that your lawyer, Kate Franklin, asked for a senior judge, but we're not going to do a senior judge. I'm going to handle it. She said that she would take it off the calendar and specially set it. That then she proceeded to talk about family law matters and her own family law matters that she knew, and it gets ugly, and she doesn't want that for Miss Alexander, and that she was her soror and had her back. And she said that like 3 or 4 times.
Okay. During the conversation I'm sorry, let me back up. You said she talked about family law matters and her own family law matter. Do you mean that Judge Williams referenced something specifically like to her personal life?
Yes.
Okay. How was Brandy responding during the call?
She was very quiet and very concerned. She takes guardian cases in Fulton County, and then she had a case with her daughter in there, and I think she was really flustered and did not know what to say. So she was shorter. Judge Williams did most of the talking.
Okay. Is what you have testified to, does that complete your recollection of what you overheard of that conversation?
I believe it does.
Okay. When the call concluded, what happened?
So when the call concluded, she took it off, and we both sat there in pretty stunned silence. And she said, "Oh, I don't know what to do. I don't know what to do." I told her it was an ex parte conversation. It was highly inappropriate. That I have worked for a judge, served as an administrative law judge. It is not appropriate. It was not simply about scheduling. It was about her taking care of her in a family court matter and their connection as a sorority sister. And I told her that was my assessment of it.
Okay. Did you, after overhearing this, did you think about reporting what you had heard to the JQC?
I really struggled. I really struggled through the end of that year, deciding whether or not to report it to the JQC. An attorney reporting a judge, it's a big thing. I finally decided when I learned, because I did not know she was going to file the motion for recusal, I didn't know at the time, that I was in the 4th quarter of my career, that it was important for me to stand up and say what I saw.
And at some point, you were interviewed by the JQC about what you overheard.
Yes, I was.
Okay. All right, Ms. Smith, I think that is all I have for now.
Thank you.
Good afternoon, Ms. Smith.
Good afternoon.
We met briefly in the hall for the first time.
We did.
Right. Just going to ask you a few questions. You mentioned that you've been in family law for 36 years, right?
Yeah, I've done things involving children and family law, right? I've represented children with disabilities, parents.
How much of your practice is in Fulton County?
Currently,
Yes.
I would say currently it's only about 30%. I serve as an arbitrator really frequently and a mediator, and a guardian, so I'm not litigating as much.
The 30% of your practice in Fulton County, is that as a gall or litigating?
It's both. You know, I can't really come up with the exact numbers right now. It varies from year to year. I probably have 3 guardian cases in Fulton right now, don't hold me to it, and then about 3 pending matters where I represent a party.
In 2020, was your practice the same in terms of it being 30% in Fulton County?
I think it might have been a little more then. As I recall, it's primarily Fulton and DeKalb, with some Cobb and Gwinnett, and then I go to other places too, but it's really Fulton and DeKalb.
In 2021, if you can think back to 2021, you had cases in Fulton County Family Division, is that right?
Yes.
Did you have cases with the 4 judges in that court?
I believe I did. I can't tell you for sure, but they get assigned randomly, and there are 4 of them, so you're just going to pop in.
Did you have cases pending in Family Division 3 in 2021, which was the family division that Judge Williams was assigned to?
It is likely that I had one. I don't have a specific recollection, and the reason I think one would be the most is I really struggled for whether or not I should file for her to recuse in my case, because I didn't want to disadvantage my client.
Okay. Did you file a recusal in that case?
No.
Okay. Do any judges have your cell phone number, Ms. Smith?
Right now, Judge Kevin Farmer does, because I did a reception for him, just like I did Miss Williams.
Okay.
And she has mine as well.
You've talked to Judge Farmer on your cell phone?
Yes,
Have you had cases in front of Judge Farmer?
yes.
How?
And if I may just tell you, the times I talked to him on the phone, he called me to ask me to be a guardian. He had a case in front of him that was thorny, and he wanted to see my availability.
Okay. How about Judge Ellerby? Do you have her cell phone number? Or do
No.
they have your cell phone number?
No.
Okay. Judge Schwal?
Judge Schwal, now he does, he didn't at the time.
Okay. Have you talked to Judge Schwal on your cell phone?
I have in the last year, but I don't have any cases in front of him.
Would you be considered, I understand that you do guardian ad litem work, and I'm learning that there's a thing called a high asset gall. Are you a high asset gall?
Well, I don't really know. I would never call myself that. I would say that I am a guardian ad litem with significant experience and expertise in certain areas like mental health, substance use, special needs. And so those are the cases that either judges ask me to serve on or the parties agree for me to serve on. Some of them have high assets. Some of them have very little. You know, I have one right now where the guy's on disability and sends me $10 a month.
Okay. Do the high asset work, is that considered a specialty?
I'm not, for a guardian,
Yes.
not really, because we're not involved in the financial part. So that terminology, I'm just not familiar with. High asset divorces, I am.
Would it be normal for your a high asset, which is a new phrase I understand now that I didn't before you started talking? Is that a higher hourly rate for a high asset as opposed to somebody with money like me?
So if you don't mind, I'll tell you how it works.
Please.
So guardians are appointed in one of two ways, or really 3 in Fulton County. Either the parties agree, and that's typically sometimes senior guardians or guardians that folks have seen. So it's a known quantity, so that the lawyers will agree to that appointment, and that's a certain rate. Sometimes the court will ask you to serve, and it's the same rate. Mine's always the same.
What's that rate?
My rate is $425, and my litigation rate's $5.75. So as you can tell, it's a labor of love. There's one other way in Fulton County. AVLF maintains a list of folks that they've trained. And if you participate in the AVLF training and take some pro bono cases, then you're eligible to be on a reduced fee list that sometimes the judicial officers refer off of. And I don't know what that reduced fee is. I think maybe $150 an hour, but I'm not sure.
Thank you.
Do you know Brandy Alexander's hourly rate as the GAL?
I have no idea.
Okay. Did you know at one time?
At one time I would have.
Okay.
I would have. I'm not trying to be evasive. I just don't remember.
In 2021, did you know the range of her rate?
I would think it would be between 175 and 2.25 maybe,
Okay.
but I'm speculating that.
Did you consider Miss Alexander a mentee?
I did.
Do you still consider her a mentee?
I do. I mean, she's gotten more senior and doesn't come to me as often, but I certainly did in Guardian Matters.
I think I've heard you refer to Miss Smith as the Queen of Gaul.
No.
No, that's unfamiliar to you?
I'm
Gaul
the
Queen?
old. The old. So I think the reason people say that is, you know, the Guardian program really in Georgia, but primarily in Fulton, was birthed out of AVLF. And it was birthed by Dan Bloom and Debbie Siegel. Dan was the deputy director, and then I came on and I ran it. So we have been some of the primary trainers for years, and so that's why you may hear they're around, they're thorough, they get it done, that kind of thing.
So you are familiar with you being referred to, even if you don't refer to yourself as the Queen Gaul, you're familiar with that reference to you?
No, not the Queen. That really is the first time I heard it.
Okay.
People will say, you're very experienced, you're really good, you're the best, but I've never heard Queen.
Okay.
Although I tell my husband to call me that all the time.
You know Rebecca Reeder, right?
I do.
Okay. How long have you known her?
I've known her. So I left AVLF in 2013. I may have known her before then, and so when I moved into private practice, she was at Davis Quigley and Matthews, and I probably started to know her more then.
So what year was that? I'm sorry.
When I left AVLF was 2015.
Okay.
I wish I'd looked at my resume.
And Ms. Reeder serves as a GAL as well, right?
Infrequently.
Okay. She served as a GAL more frequently over the years than she does now. Is that fair to say?
You know, I just don't know. I never had her as a GAL in a case, so I really don't know.
Is it fair to say that you and Ms. Reeder run in the same circles in terms of family law?
We're both members of the American Academy of Matrimonial Lawyers, so through that we have an opportunity to interact more. We have a lot of common friends.
Okay.
It's a small bar.
Are you friends with Ms. Reeder?
Yes.
Have you been out to dinner?
I've been out to dinner in Chicago at a conference with about 10 other people, and she was there.
Okay. Have you been to her home?
No.
Has she been to your home?
Nope.
You contributed to former Judge Reeder's campaign, isn't that right?
Yes.
Okay. $500, is that right?
If that's what it says on the disclosures, yes.
And you contributed to Judge Reeder's campaign after Judge Williams declared, is that right?
Probably. I don't know the dates, but probably if you have those records.
And your firm participated in a fundraiser for Judge Reeder's campaign, is that right?
Yeah, we did the same reception for Judge Reeder that we did for Judge Williams. It was just that it was during COVID, so it was virtual.
Well, I mean, you didn't support Judge Williams' campaign, did you?
Well, not afterwards. She had been elected.
Okay.
It was an introduction to the family bar, and for her to begin to have those contacts in order to gather support.
Okay. You mentioned that reception before. I'm talking about a reception for Judge Reeder's campaign.
Yes.
Okay.
Yes, she was on the bench a year, and I did a reception during that year.
Okay.
I think pretty early in her tenure on the bench.
But you did not participate in a reception for Judge Williams as she was campaigning?
right?
Oh, I wasn't asked or invited.
Okay.
Do rookie judges get put into the family division right away?
Well, they can talk more about it. It's a place that most judges, I understand, don't want to go. So I think what they've started to do now, this is my understanding, is the most senior person and the youngest person, like they rotated the placement. That's what I understand. But
And you threw a fundraiser in support of Judge Reader's campaign. Is that right?
it's that same reception you're referring to.
I've said reception before, but they're making a distinction now between a reception and a fundraiser in support of a campaign.
So when are you referring to? I'm just not sure.
Sure. March 26, 2019.
If that's what it indicates in my financial disclosures, I may have, I know that I had a hey reception, she's on the bench meter, and we collected money. I may have co-hosted another, if you're seeing that. I'm just not sure.
I can refresh your recollection
Okay,
if you'd like.
thank you, yeah. Let's hope I can see.
I will show you two documents that I'll represent to you are the campaign contribution disclosures for Judge Reader.
Yeah, and I don't have my glasses, so we're going to do our best. Okay.
To make it easier, I flagged the page.
Okay. Oops, another page. Okay. Dawn Smith, attorney, Smith and Lake, 3/10/2020. Yes.
For $500?
Yes.
That was the first one I asked you about.
Okay.
And then the second one I asked you about was a fundraiser in support of Judge Reader's campaign. And you can look at that. Where I've written on the flag, that's the page. But feel free to look to the cover if you'd like.
So this was, I think what happened. Yeah. So I gave a donation to her campaign, but all of this was the same reception. And then this is an in-kind contribution because we had food and wine there
Yes.
on 3/26.
That's just other
Okay.
contributions to her campaign.
Yeah, those are and generally, if you're looking at the same time period, it's the folks that came to the reception. So I would say that's all related to the same event.
Thank you.
Mm-hmm.
You didn't raise any funds for Judge Williams, did you?
I don't know that I did or that I was asked.
Okay. You don't know? That you did?
If they're not there, then I didn't.
Okay.
This all happened really early in her tenure. So I would not have given after what I listened to.
So, when Judge Williams was running for judge, before anything that you listened to, Judge Williams was running for judge in 2020.
Right.
You testified to a conversation that happened in 2021.
Right.
So I'm asking you about the campaign period
Okay.
where Judge Williams ran against Judge Reader.
Then no, I did not donate
Okay.
during that period. Thank you for clarifying.
Did you donate financially during any other period?
No.
Okay. The Atlanta Bar Association, I understand, does a family law luncheon. Are you familiar with that?
I am. I'm the former president of that section.
What year were you president?
I believe in 2022, 21 or 22, 22.
Okay. Do you serve on the committee for
What?
the family law, the Atlanta Bar Association's family law section? Are you on the committee that puts on the luncheon?
So I was an officer for the board, and the board makes the decision about the luncheon and everything else.
Okay. Let me back up and ask you this. I asked you about your contributions to Judge Reader's campaign $500, and then a campaign fundraiser. Were you upset when Judge Reeder lost the election?
Oh, I was surprised. I thought she had done a good job.
Were you upset?
No, I don't remember being upset.
If somebody says you were upset, would they be mistaken?
I don't think so. I think I was shocked.
Okay. If someone says that you were tearful, would they be mistaken?
I really think they would be mistaken.
Okay. Did you have any involvement in the Atlanta Bar Association's Family Law Luncheon in 2024?
I was off the board then, and I did not go.
Do you know whether, if all of the family law judges are typically invited to the luncheon?
I think the policy has been that the entire Fulton bench is invited.
Okay.
And then the invitations go out from the Atlanta bar. Like, I'm not sending invitations as president. It's Karen English and the Atlanta bar does that.
Okay. Do you know whether or not Judge Williams was invited to the 2024 luncheon?
I have no idea. I didn't attend and I wasn't on the board any longer.
I think you mentioned at the end of your questioning from Director Veal that you sat for an interview before the investigative panel of the JQC?
I didn't sit for an interview. I talked to Ms. Veal at some point about my experience witnessing that call, but I don't know that I had a formal interview.
Were you asked to have a formal interview?
I don't recall.
Okay. Were you asked to be present for a deposition?
No one asked me to be present for a deposition.
I'm not sure what a formal interview is, so.
Sure. What I meant, if you didn't understand it, was an interview that had the members of the hearing, the investigative panel present,
No,
and you weren't asked.
no,
Did the investigative panel ask you to submit a statement of any kind?
no,
An affidavit?
no. I don't recall any of that.
And nothing that would be reduced to a writing did the investigative panel ask you to do?
Not that I recall.
Do you know why?
I have no idea.
Now, you just mentioned that you, at some point, you spoke to Director Veal before today. Was anyone else present?
No,
Did you ask for anyone else to be present?
no,
You may not know, or maybe you've been introduced to my colleague Gabe Banks,
Right.
who's representing Judge Williams.
right.
Do you recall that he reached out to you and asked you for some time to talk?
I did. And the
Okay.
difference is I talked to Ms. Veal before she filed any charges. After they were filed and it looked like it was going forward, what I told Mr. Banks in an email was, let me just come to the hearing and everybody can hear what I have to say.
Why was that?
Why was that? Because I didn't want to, if I did it, I wanted it to be with both of them. I live in a world, as a guardian where all the time, Dad's lawyer will say I said this and Mom's lawyer will say I said that. So I said, I'll talk at the hearing. I didn't want to sort of get it separate.
So even though you had already talked to Director Veal, you weren't going to talk to Judge Williams' lawyers?
Well, not in response to that email, which I think was about it was right before the hearing in March this year.
Did you speak to Director Veal another time other than the one time that you mentioned?
I spoke to her last week about the logistics of this because I was desperately trying to figure out what day so I could adjust my schedule.
Any other time?
Not that I recall. There may have been some.
How about an investigator with the investigative panels team?
No.
Your conversation with Director Veal about the substance, was it on the record?
I wasn't her. I don't know if she made it on the record.
I don't know what that means either.
Sure. You don't know if she reduced it to a writing that she asked you to look at to see if it was an accurate representation of what you had told her?
I never saw that.
Okay. When you met with Director Veal, how long was it? How long did you meet with Director Veal?
I can't remember. Maybe a 30-minute phone call. It wasn't in person.
I want to switch gears and ask you about the conversation that you listened in on Miss Alexander's cell phone.
Yes.
You don't know at what point in the conversation you came in, do you? Had the two of them been on the phone for a few minutes or however long?
When she was on mute, she said she just called.
Okay.
So that's what I know. But she had to come from Tammy's office, so there could have been something before that.
How far away was Tammy's office from your office?
Yeah, it's probably from right here to over there. You have to go around a little bit.
Okay. Was your door closed and she had to knock and come in?
I don't recall one way or another.
Okay. What was the first thing you heard?
I believe the first thing I heard was my JA, my judicial assistant, said this was ex parte, but I told her it wasn't, it's a soror.
Okay.
That's what I recall.
Okay. About how many minutes of the conversation did you hear?
I think it was about 10 minutes. It felt interminable. I was very uncomfortable.
Did you hear the call through the end when they hung up?
Yes,
What was the last thing you heard?
I have no idea. I can't put it in that type of specificity. It was, I'll handle the scheduling, I'll take care of your soror, and I know what it's like, and you don't want your business out there. So I'm not quite sure what the last thing was.
You didn't overhear a discussion about the substance, the merits of the case, did you?
Well, when she was talking about that she had been through a divorce, and she goes, I know this is about your kid and it's important, but nothing else about that.
About the merits of the case?
Well, she didn't conduct a hearing on it, no.
No.
Other than referring to this as about your child?
Yes.
No.
She didn't mention anything about a ruling, how she would rule one way or the other, did she?
No.
And Judge Williams didn't say that she would rule in Miss Alexander's favor, did she?
No, she said she'd take care of her.
You don't know what Judge Williams meant by that, do you? You can't know, right?
I can't know because I have never heard a judge do this ex parte with a litigant.
You didn't hear Judge Williams say anything about on the shield, did you?
I don't know about on the shield. I heard soror.
Okay. Second. You didn't hear Judge Williams say anything about putting her attorney on a three-way call, did you?
I don't recall that. She did reference that I know your attorney called and wanted a senior judge, but I'm going to handle this.
But nothing about, let's get your attorney on a three-way call now?
I don't recall that.
Okay. Nothing about, we're going to tell your attorney about the plan?
I don't recall that being said.
If that were said, you would recall it?
I don't know that I would. I mean, Brandy was going to tell her attorney. I just don't recall that.
Okay. But you recall soror?
Yeah, several times.
Wouldn't you think it's significant if Judge Williams told Miss Alexander that let's get your lawyer on the call so we can tell your lawyer about the plan we've come up with? Wouldn't that stand out to you?
So, yes, because
Okay.
then it's both of them speaking with her ex parte.
Mhm.
I don't know how that makes it better.
Okay, so
It's
you-
an ex parte conversation with an attorney on it.
Understood. Excuse me, one moment. I'll make it right.
Certainly.
Sure. Are you familiar with the ex parte rules?
Barely.
Okay.
I'll tell you what I know.
Okay.
I know that it's simply that guardians, for instance, I am incredibly careful about ever approaching the court. And I know there's a uniform superior court rule that permits it under certain circumstances, and I abide by it all the time. Being told by a judge that you're going to take care of a litigant, in my mind, falls into that ex parte. It wasn't just about scheduling. It was her reaching out about a request that had been made that the other side should have known was made.
You don't know if the other side knew about the conversation between Judge Williams and Ms. Alexander or not, do you?
Well, what I do know is the transcript that I read of the subsequent hearing, and they weren't told.
Why would you read the transcript of a hearing?
Because it's contained in the complaint. I mean, at some point, it's contained in excerpts of it in these charges. I've read the excerpts.
So did you read the transcript or did you read the
I'm
pieces
sorry.
that were excerpted for
I
the
read the
purposes?
excerpts.
Hold on, we can't talk over each other. I
You're
didn't mean
right.
to interrupt you.
You're right.
I thought you mentioned that you read the transcripts. Is that right?
What I was referring to were the excerpts that I read.
From the formal charges?
Yes.
Okay. Not the entire transcript that had the context of the conversation?
Not that I recall reading the entire transcript.
Okay. Are you familiar with, and I think you are based on what you just said, there are improper ex parte communications and ex parte communications that might not be improper. Is that generally fair to say from your understanding?
I'm going to object on relevancy grounds. I'm not sure her understanding of a specific provision of the Code of Judicial Conduct, how that is relevant.
Response?
She's also already been testifying about it and what her understanding of the ex parte rules are. But I'm wrapping up now anyway.
Okay, yeah, I mean, I don't know that she's the right witness to ask this question of, so maybe move on to a different area with her.
I think I'm just about done. Okay, thank you.
Thank you.
Anything on redirect?
Ms. Smith, why did you host the reception or fundraiser for Judge Reeder and give her a campaign contribution?
Because I do it for most of the judges. I did it for Judge Glanville when he was on the bench, Judge Farmer when he was on the bench. You know, with Schwall and Ellerby, they came on after COVID and weren't as excited about doing that. I'm doing one for Charlie Bailey in state court right now in DeKalb. I've done one for Doug Lake in Brian Lake. So I think it's important they come on and they don't know the family law bench. So it's to introduce everybody to the family law bench and begin to establish a professional relationship.
Okay. And you testified earlier you did the same thing for Judge Williams
I
when
did.
she was elected. Okay, but obviously you supported Judge Reeder. She was somebody that you knew, and you hoped that she won that election. Is that fair to say?
It is fair to say she was a good judge. I had no reason to think that she wouldn't continue to be one.
Okay. And at the time that Judge Williams, well, then just Miss Williams qualified to run against Judge Reeder, did you know?
I had
Ms.
never
Williams
been
at all?
introduced or didn't know her.
Okay. The portion of the call that you overheard where you said, Judge Williams said that her JA said, you know, should you have that call or that call's an ex parte communication, is it possible that she referenced a staff attorney and not a JA?
It's possible.
Okay.
I don't know that. It's possible.
Is your practice limited to being a guardian? Do you do other law?
No, I litigate. I mediate very frequently in family law matters and I arbitrate.
Thank you.
Ms. McFadden was asking you about the fact that you remembered
a certain piece of the conversation, and that was the mention of the soror. Do you know why that piece would have stuck out to you?
Well, because of the difference, and it might be what she was trying to get to, between maybe, I can't imagine, somebody like Judge Farmer calling me and saying, hey, I got to bump you off this calendar, just want you to know I'm going to get you in. So I still think that's scary, but this also was that, and I'm going to take care of you. You're my soror. Don't worry, I got you.
But that piece stuck out to you, why?
Because it seems as if there's favoritism, and if I represented the other side, I would absolutely want to know about that call and the content of that call.
Thank you. That's all.
Would you want the witnesses to be freely talking to you after they've talked to the other party?
The witnesses.
Whatever matter you're doing.
I'm just.
My point is, I'm trying to understand that you would talk to the director's folks, but you wouldn't talk to Mr. Banks, and I was just asking, do you
Right.
experience that same type of conduct in your other cases when you're lawyering?
Yeah, I mean, I experience witnesses that won't talk to some people and will talk to, and I want to be clear, this was in the investigative phase, and I just talked to her and told her what I heard. And then it was a couple years of silence. And then right before March, Mr. Banks contacted me, and I'm like, let me just get on the record so everybody can hear the
Understand.
same thing.
Anything else from either side for Ms. Smith?
No.
May we excuse her?
Yes, Your Honor.
Thank you. You're free to go.
Thank you.
Okay. You can go ahead and get the next witness ready. We're just going to take a quick 5-minute comfort break while that next witness is getting ready, okay?
Who's next? Do we know?
Don't know.
Can we take Will you raise your right hand for me? Do you swear or affirm that the testimony you will give in the matter now pending before the hearing panel of the Judicial Qualifications Commission will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Will you please introduce yourself and spell both your first and your last name for us?
I'm Brandy Alexander, BrandyAlexander.
And Ms. Alexander, you're an attorney here in the state of Georgia.
In Florida, yes.
Okay. What year were you barred?
In Georgia, 2008,
Okay. What about Florida?
2006,
Okay. Where did you start practicing law?
Florida.
Okay. What did you do there?
I was a public defender.
When you eventually came to Georgia, what area of the law did you practice?
Criminal, I was a public defender in Clayton.
Okay. How many years were you a public defender there?
3.
Okay. Have you, as far as your Georgia experience, what other area of the law have you practiced in?
I currently practice family law. Before I went out on my, or immediately after going out on my own, I practiced what I call door law, where anything that came through the door, I took it. But once the family cases picked up, exclusively family.
Okay. What year did you go out on your own?
2015.
Okay. And you mentioned at some point the family law cases began to pick up. About when was that?
I took several cases with me when I left the firm, so maybe mid-2016.
Okay. And when you left, you mentioned a firm. Were you at a firm before you became a sole practitioner?
Yes, I was at the Manili firm.
Okay. And so you brought some cases from the Manili firm?
Correct.
Okay. Have you also done guardian ad litem work?
Yes,
Okay. When did you start doing that?
2015. But I did it pro bono in 2015. I started taking paid cases in 2020.
Is that common that people start out doing pro bono guardian ad litem work?
Well, in order to become a guardian, most people get trained through AVLF, the Atlanta Volunteer Lawyers Foundation, and they require that you take at least one pro bono case. So I think so, yes.
Okay. Attorney Don Smith, do you recall about where you were in your career when you met Dawn?
When I met her, no, I don't remember.
Okay.
But I'm pretty sure I was out on my own.
Okay. Is Dawn somebody that has been a mentor to you during?
Absolutely.
Okay. And at some point, did you begin renting office space from Dawn?
Yes, that was right before COVID, so February 2020, I think.
Okay. Let's talk about your business around that time in February of 2020. What percentage of your business at that time would you say was guardian ad litem work?
Almost 100%.
You said almost 100. Were there a few other cases that you had?
Yes, I had cases where I was the litigator, but I closed the litigation side of my practice in 2020 and turned it into an exclusive guardian practice.
Why did you close the litigation part of your practice?
I felt like I did more good as a guardian. I really didn't like litigating anymore.
It gets old.
It does. And I was so used to having to fight for one side, and even when I didn't necessarily think that it was in the best interest of the child, I was advocating for that. And guardian work let me actually do what I thought was in the best interest of children. And I got to hold babies, so that was always great.
With your guardian work in 2020, let's say, was it primarily concentrated in one county?
Early on, it was primarily Fulton, and then it kind of expanded to Fulton and DeKalb, and then it blew up, and it was all over the metro area.
Okay. And was that around that time, around 2020?
Yes.
Okay. Can you explain, I know there are different ways you can become a guardian on a case. Can you explain the different ways?
There are two. The attorneys can agree to use you and ask the judge to appoint you. So they would give my order, they would give it to the judge would appoint me, or a judge can just appoint you of their own free will and accord.
In 2020, in Fulton County, tell us what your guardian cases looked like. Did you have guardian cases in front of all of the judges on the family division at that time?
I think so, yes.
Did you ever practice in front of Judge Rebecca Reeder?
I did.
Okay. How many times do you think you appeared in front of her?
A good many.
Okay. And had she appointed you as guardian on cases?
No, not that I can remember.
Okay. So when you appeared in front of her, what capacity was that in?
I was a litigant's attorney.
Okay. When, at the time, it would have been Miss Williams. When Miss Williams qualified to run against Judge Reeder, did you know Miss Williams?
I did not.
Okay. Once she was elected and became Judge Williams, did you reach out to her?
I did.
Okay. And why did you do that?
Because when Smith and Files threw their welcome to the family bench virtual party for her, I was sick. And so I reached out to meet her, introduce myself because judges give guardians work. I asked for a virtual meeting. It was during COVID, so we met virtually.
And how did that meeting go?
It went well.
At some point during that meeting, or before that meeting, did you realize that you and Judge Williams were members of the same sorority?
I don't remember if it was before or during. I want to say it was probably before, but I don't know. But yes.
Okay. And after that meeting, did Judge Williams begin appointing you as a guardian on some of her cases?
Yes.
Okay. I want to direct your attention to your personal matter that was filed in Fulton County in 2021 that was assigned to Judge Williams. So September 17th of, I'm sorry, September 14th of 2021, a petition for modification of parenting time and contempt was filed by Mr. Carey in the Superior Court of Fulton County. Who is Mr. Carey?
My daughter's father.
Okay. And who was your attorney on that matter?
Catherine Franklin, but I call her Kate.
Okay. And had she been your attorney previously?
Yes, Kate's represented me since my daughter was about 3. So I think she and I established an attorney-client relationship around 2016.
Okay, and when you became aware of the petition that was filed in September of 2021, Kate was your attorney. Do you recall Kate making a phone call to Judge Williams' chambers about a senior judge?
I know that she did that, yes.
Okay. Was there a reason that Kate was inquiring about the process for obtaining a senior judge in your matter?
So as soon as I got served, I was at my office when I was served. I called Kate and told her that I'd been served. At that time, I was a guardian for, if not every judge, nearly every judge in Fulton. And I said I did not want a judge to hear, a Fulton County judge to hear my case. So we talked about a senior judge, but we didn't know the procedure to get a senior judge to hear the case. So Kate said she would find out.
Why didn't you want a Superior Court judge in Fulton County to hear your case?
It gets very messy. It's very ugly. I did not want all of those judges who generally appoint me to hear my dirty laundry, essentially. I worried that it would affect my business.
On October 18th of 2021, at some point that day, did Judge Williams contact you?
I don't remember the date, but yes, I was contacted by Judge Williams.
Okay, and was it in reference to your personal case?
Yes, it was.
Okay. Where were you when you received that phone call?
I was on Dawn's side of the office in one of her associates' offices.
Was it abnormal as a guardian ad litem for judges to call you directly
Not at all.
about guardian cases?
No, not at all.
Okay. So when you saw that, I'm sorry, did you have Judge Williams' number in your phone?
Yes, I have
Okay.
tons of judges' numbers in my phone.
Okay. And when you saw that she was calling you, what was your thought?
I figured it was for a case,
Okay.
a guardian case.
Okay. What was the first thing that was said when you picked up?
She said that someone had just called her office claiming to be my attorney, and it's been a while, but essentially that somebody had called her office claiming to be my attorney, and she was calling me to find out if it was true.
Okay, and how did you respond?
I said, yes, it's true. I validated it for her.
Okay. Did she inquire about, or did she say anything about that person inquiring about a senior judge?
Yes.
Okay.
She said that someone had called to find out how to get a senior judge on my case. She asked why I wanted a senior judge, if I was embarrassed by what might come up. I said I am. And at some point she said she would close the courtroom and, take me out of the limelight of my potential clients in cases in which I was the guardian.
Okay. At some point during that phone call, did you leave the office that you were in and go into Don Smith's office?
Very early on, yes.
Okay. Why did you do that?
Well, I don't exactly know. I knew that once we started talking about my case, I felt like I needed to have somebody who was more well-known and more believable than me in the event that it became an issue. Dawn is a white, prominent family law attorney, so who better, in my opinion, to have listened to that conversation in the event that it went awry.
Ms. Alexander, you just said someone more believable, and I'm going to need you to tell us, why would you have that thought? Why did you have that thought?
Sure. I mean, this panel is mostly white, so I don't know how this is going to come off, but as a black woman in the South, I don't think that I would be the most credible person to battle against a judge, even another black woman judge. But I think that Dawn Smith had a lot more credibility. She was far more well-known, unlike me. And if I had to challenge a judge, the person that I would want standing next to me would have been Dawn.
All right, so when you go to Dawn's office, what did you do when you got into her office?
I told her that the judge was on the phone, like I pointed to my phone and said that it was the judge. And then I sat in her chair facing her desk, and I put the phone on the desk at first. But then I thought it might be obvious that she's on speaker, so I took the phone back and held it.
Did Judge Williams, during the call to you, reference anything about one of her staff members expressing concern about the call?
Yes, she said that when she said she was going to call me, when Kate called, she said she's just going to call me. She has my cell phone number, so she's just going to call and find out if Kate really was my attorney. And Janelle Bowles, I think was her name, told her that that was an ex parte communication and she shouldn't do it.
And then what did she say after that?
She said that she told Janelle that I'm a soror, we're in the same sorority. Apparently Janelle was too, and that it would be on the shield.
All right.
which essentially means it's like a swear.
You knew I was going to ask what on the shield meant.
Yes.
Okay. What did you think of that piece of what Judge Williams had to say?
I thought the entire conversation was inappropriate.
All right. You mentioned that she said that she was going to move your case. So that piece of it, can you be more specific? Are you able to be more specific?
So she just said that she was going to we were scheduled for a 30-day. In Fulton, they have a 30-day, 60-day, and 120-day status. Those statuses tend to be in front of a judicial officer. She said that she was going to take my case off of the 30-day calendar where we would be on Zoom with a ton of people because it was COVID and exclusively Zoom. So she would take us off of that and close the courtroom so that it was just the litigants, essentially. And their attorneys, obviously.
Did you respond to that at all?
I said, okay.
Okay. Did she address the senior judge issue during the call?
I vaguely remember her saying something along the lines of a senior judge could only hear one case, like one day for a case. And I knew that that was wrong because, like I said, I've practiced criminal law and we've had tons of senior judges come in and do like week-long trials. So I thought that that was odd. I thought she probably just wanted to hear my case and be in the know about what was going on with my daughter's father.
Did you share with her why you might be embarrassed about her hearing the case?
Not in any real detail. I just said that I'd be embarrassed.
Okay. Did she share with you anything about her personal background when you talked about the embarrassment piece?
Yeah, so when I said that I'd be embarrassed, she said that she understood that she has a husband who says all sorts of stuff about her and she doesn't care, but she gets it.
At some point, did...
I'm sorry, her
Go
exact words were that she had an ex-husband and that nigga talks so much shit about her that she didn't care, but she understood.
At some point, did Judge Williams ask you whether you wanted to loop your attorney in on the call?
Yes, toward the end of the call, and I said no, that Kate had just walked into a meeting.
Okay. Was that the truth?
No, I hadn't talked to Kate immediately before that. I just didn't want, I knew it was an ex parte communication, and I didn't want to pull Kate into that. I didn't want to put her in that position.
How did the call end?
Pleasantly.
Okay. After the phone call ended, how did you feel?
I called Kate, and I told her, well, I talked to Dawn for a bit, and then I called Kate, and I told her what had happened.
Is she waiving privilege?
Well, are we about to say what she said to Kate, or were you just? Yeah. In other words, are we going into the content of what she said to Kate, or just that she called Kate?
I was just going to ask whether she called her and advised her about the call.
Well, I mean,
That'd
call
be a
or
communication.
advising is a substance of a conversation. So we need to know if she's waiving privilege concerning her conversation that she had with her lawyer.
Yeah, I agree.
Okay, so let me ask it this way. Did you call Kate? Did you speak with Kate after the call with Judge Williams?
I did.
Okay. After that call occurred, You said earlier that you knew it was ex parte. Did you consider reporting that to the JQC?
No.
Okay. So no, you didn't consider it?
No.
Okay.
Why is that?
Can I waive privilege? Can I do that?
You asked the wrong guy.
It's your right.
Yeah.
so
I'm
ahead.
going to waive privilege.
Okay.
So Kate and I, when I called her, I told her about my conversation with the judge. And at that point, she's like, I think we both have an ethical obligation to report her. And I said, we can't report her because they're going to trace it back to me. And if she's still on my case, that's going to be all bad for me and my daughter. Kate spent a great deal of time trying to convince me that we needed to report it. I did not agree to that. And after that, at some point, Kate called me back and said she was not going to be my lawyer anymore because she thought that she had an ethical obligation, and so did I, to report it. I cried and I begged her not to withdraw from my case or not to leave me as her client. And then I reached out to another attorney who had represented me previously and asked him about it. He said that we did not have an obligation to report it. I don't remember why he said that. I don't remember his logic. So I told Kate that, and she said she had done her own independent research, I guess, and that she would stay on as my attorney.
Okay. Why were you so opposed to reporting it?
Because I knew it would come back to me. You can't file a motion to recuse without the judge knowing who's filing the motion to recuse, and the judge gets to decide whether or not they recuse. And that would, as an attorney, I've been practicing for almost 20 years. I've never filed a motion to recuse prior to my own personal case. It's just frightening.
How did you feel after that phone call about how your case might go in front of Judge Williams?
The phone call with me and Kate,
The phone call with you and Judge Williams, I'm sorry.
I didn't really feel one way or the other. Like I said, I thought that she just wanted to be in the know. I think you're asking me if I thought that she would rule in my favor. I definitely considered that, yes. But the bigger piece of that, I think, was what I've already said.
Okay. All right, so Kate agrees to remain your lawyer, and I think the next event in the timeline of events would be the motions hearing that occurred in December of 2021. Is that fair?
Yes.
Okay. At that motions hearing, did it come up, or the fact that you had cases as a guardian pending in front of Judge Williams, did that fact come up?
Yes, the judge put everybody on notice.
Okay. At that point, you and Kate did not seek to have Judge...
Try to rephrase if you can.
At that point, did you and Kate seek to have Judge Williams removed from your case?
No.
Okay. And why is that?
I don't have an answer. I didn't have an answer the last time you asked me either. We just didn't. I know that his attorney, my daughter's father's attorney, asked. She did an ore tennis motion to recuse, at which point the judge responded and then Kate responded. We just didn't.
Do you know about how many cases you had before Judge Williams at that time?
I don't.
More than one or two?
Possibly.
Okay. let's fast forward to the January 2022 temporary hearing. Do you recall that hearing?
Yes.
Okay. When you left that hearing, did you feel as if it had gone well for you?
No.
Okay. Why?
It was insane. So a number of things happened at that hearing that I remain. I don't have words for it. So, for instance, my daughter's therapist testified, and at some point she needed to go and notice one of her clients that she was running late. She asked the judge if she could do that. The judge would not allow her to take a 5-minute break to tell her client that she wasn't coming. At some point, the judge threw her pen down on the bench. She was asking the therapist a series of questions. She kept asking the same question a different way, I think.
Do we have that transcript?
We do.
Okay.
But either way, the therapist kept answering the same way, and the judge got frustrated and threw her pen down, and then she started eating chips. And I think it was chips. She started eating from the bench out of something in a bag. And we were on Zoom. I took my phone and I took a picture because it was unlike anything I've ever seen in my life.
When you say she started eating chips, who?
I think it was chips. The judge started eating on the bench. I don't know what she was eating, but I want to say it was potato chips. At some point, she kind of took over the cross-examination of my daughter's father. She asked if maybe my daughter, give me a minute. So what the therapist had testified that Cadence and her dad didn't have a very good relationship, that she was fearful of her dad, things like that. I don't remember the therapist's exact words. But the judge asked, well, do you think it's possible that because Cadence's dad only sees her on weekends, that he's a stranger to her, and that's why Cadence doesn't know that when he says things like "you're dumb," he's joking with her. There was no testimony that he was joking with her. So yes, I thought it went badly. I believe it was also at that hearing where the judge wanted to do an in-camera. We had filed a motion for in-camera communication with Cadence.
And tell us what that motion, what is that?
That just means that we want the judge to speak in chambers to the child.
Okay. And you had filed that motion?
Yes, we filed that motion. So at that hearing, the judge said, at the end of the hearing, the judge talked about getting Cadence in chambers, and there would not be a court reporter, the attorneys could not come in, she would not transcribe it, and she cited a case, I don't remember what case, that said that she didn't have to do any of those things. And I knew that that was wrong as well. And I ended up talking to someone that used to work in her chambers who kind of doubled down. Let me say, I don't remember if I talked to the person in her chambers before or after that conversation or that hearing, but I did at some point in all of this talk to someone who said, don't let her talk to Cadence.
Who was that?
That was Tangi.
And what did she say about why?
So it's widely known that the judge favors dads, and Tangi kind of doubled down on that, and she said that if she gets Cadence in chambers, what she tends to do with children is have them say nice things about their dad, and then she uses that to essentially say why dad should get custody. And the only way that I should agree to allow Cadence in is if she agreed to have a court reporter there.
Okay, and that was a communication from somebody on Judge Williams' staff to you?
She wasn't, I don't think she was on Judge Williams' staff anymore.
Okay,
But
so
formally,
she had
yes.
left.
Yes, she was a staff attorney.
Okay. Did you all at some point withdraw your request for the in-camera?
That was our intent, but it didn't happen before that hearing, I don't think, because it came up, so we couldn't have filed it.
Okay. Well, let me ask it this way. Who is Nigel Hunter?
She's a friend of mine who is now a prosecutor down in Clayton, but she used to practice family.
Did Miss Hunter end up, was she going to be a witness in your matter, or was she involved somehow?
So I wanted Nigel to write an affidavit because my daughter had talked about her dad hitting her really hard. She was like 3 at the time, and she had talked about her dad hitting her really hard. And Nigel was there when we had that conversation. So I wanted Nigel to write an affidavit to that effect because you can enter unlimited affidavits at a temporary hearing.
Okay. And did she write the affidavit?
I think so. I don't remember for sure.
Okay. Does Miss Hunter know Judge Williams?
Yes.
Okay. Was there something about Miss Hunter knowing Judge Williams that wound up in the motion to recuse that was eventually filed?
Yes, so when I talked to Nigel about writing the affidavit, and we talked about Judge Williams, she said that she had...
Unless you've got an exception or a valid non-hearsay use, I agree.
Okay. The judge's relationship with Miss Hunter, again, that came up in the motion to recuse.
Yes.
Okay. Can you tell us who Brandy Reeves is?
She's my line sister, so we pledged together. And friend, she was a public defender in Fulton. Now she has her own practice.
Okay. And did Brandy Reeves or Miss Reeves end up having any involvement in your case?
So I think yes, but I think you need the context behind it.
Okay.
When I was talking to William about filing a motion to recuse, he said he thinks that we need more than just the ex parte communication. I said, well, recently she was at like a party or something with Brandy and Brandy's best friend, and Brandy is a good friend of mine, so there's that connection there. And that was it.
Okay. So
Just for the record, is she also waiving her attorney-client privilege?
With Mr. Alexander.
And Mr. Alexander? I
Yes.
just want to make sure that the record is clear.
Thank you, Mr.
Yes,
Banks.
I am.
It sounds like yes.
So you left the temporary hearing. You were not feeling good about
Not
what
at all.
happened at that hearing. At what point did you talk to Mr. Alexander about filing a motion to recuse?
I had spoken to William before the hearing on the 13th. I don't remember when. I just know that I was standing outside of my mom's house, so I was in Florida. And he said, like, if you want to...
Back to what Mr. Alexander said until he's a witness in this case.
Remove
Sure.
anything that he said unless I ask you specifically.
Sure,
Okay.
we just talked about filing a motion to recuse.
Say
Sustained.
what you said.
I said I was not going to file a motion to recuse
And why did you not want to do it?
for the reasons I've already stated. It would go before the judge would decide. If she said no, she was still my judge, and I then had a motion to recuse her looming over my case.
At some point, did you authorize Mr. Alexander to file a motion to recuse on your behalf?
Yes.
Okay. Why did you change your mind about doing that?
I didn't know what else to do. I didn't know what else to do, so I said you can do it.
When you say you didn't know what else to do, why did you feel as if you needed to do something?
Well, at that point, we now have The judge, at the end of the temporary hearing, the judge had said that she was going to talk to Cadence, per our motion, and that we should give her any evidence that we wanted her to review prior to her talking to Cadence. And I think she said like video, audio, whatever we wanted to provide. And even though I'm a litigant, I'm also an attorney, I knew that none of that had been entered into evidence. So it was very concerning to me that she wanted to review evidence that had not been formally entered, in addition to the fact that I had already been told by Tangi that if there wasn't a person in there with her, it was going to go badly for my daughter and me. And just the general way that the hearing went and the way that she acted, yeah, I felt like I needed a more impartial judge.
While the motion to recuse was pending, did you become aware that Judge Williams had spoken to another lawyer about your case, a lawyer that was uninvolved with your case?
Yes,
Okay, and who was that?
Adidiong Aaron.
Okay. How did you become aware of that conversation?
Adidiong texted me.
Okay. Do you recall what it said?
She said the judge is on the phone talking about your case. She hasn't named you, but Adidiong and I were good friends, so she knew the facts. So she said she hasn't named you, but she's talking to me about your case.
When you say you and Adidiong were good friends, can you define good friends for us, what that means to you?
My daughter calls her Aunt E. Get it? Auntie. And her daughter wasn't talking yet, but I was always TT when we would refer to me to her daughter, so we were really close.
And how long had you all had a close relationship?
That much I don't know. I know that she was an intern when I practiced in Clayton, and that's where we initially met, but how our friendship actually really started, because we weren't really friends then, she was just an intern, I don't remember.
When you read Adidiong's message that Judge Williams had called her and was talking about your case, how did that make you feel? Like, what was your reaction?
I was pissed off, but not terribly surprised.
What was your response when you got that text?
I responded back to her. We had a series of messages back and forth, I think, and then she said she would call me after. So the text communications ended with her saying she would call me after.
Did she call you afterward?
No.
When did you have an opportunity to speak with her?
The next day, I think I texted her first, but ultimately we got on a phone call, and she said that she had been on the. Can I say what she said?
Yes.
She said that she'd been on the phone with the judge for 2 hours, and that's why she didn't call me back, because it was late.
Okay. What did she tell you Judge Williams said about your case?
About my case, she said that the judge said that there was a black female attorney who had filed a motion to recuse her, saying that we had an ex parte communication, but the communication was only about substance and form. And I said, what does that mean? And she said she didn't know, but she said that the judge kept saying substance and form, and that the judge said that she was going to she was worried that my motion to recuse and putting in the motion to recuse the ex parte communication was going to hurt her chances of getting reelected as a judge, that somebody might find my motion, and that hurt her chances of getting elected. She said that I was personally attacking her by filing such a motion, and that she was going to show me personal when she took my child and gave her to her father.
Is everything that you have just testified to the truth?
Objection, Boastman.
Sustained.
Is everything that you have just testified to an accurate representation of what Miss Aaron said to you about what Judge Williams said to her?
About my case, yes. There was more than that, but yes, as it relates to my case.
Okay. Would you come into this proceeding or any other proceeding and fabricate information or evidence?
Objection.
What's your objection, Mr. Banks? Bolstering?
Yes, Your Honor.
Okay.
The hearing panel can determine whether or not she's being.
I agree the way it's phrased, it's maybe problematic, but you're welcome to try to rephrase it, though.
Are you lying to us?
No, sir.
Okay, thank you. How's that?
Well, thanks, Mr.
Yeah, thanks.
I won't object.
Also sustained, yes.
Okay. Once you heard all of the things that Judge Williams said about your case, what was your response?
I said, I will set her house on fire with her in it if she takes my baby. And Adidion said, and I'll help you.
How were you feeling at the time?
Every bad emotion you can think of.
Where were you at?
I was standing in my bedroom in front of my full-length mirror, and I can see my bed made behind me because I don't often make my bed, so I guess that's why it sticks out.
What did you do after that phone call with Adidion concluded?
We got off the call. I called my mom first. I was hysterical. I told my mom, and then I called, I don't know if I called Kate or William first, but I called one of them. I know when I called William, I got his voicemail, so I had to leave him a voicemail, and I talked to Kate.
Did you go somewhere afterward?
I went to the liquor store,
What did you get at the liquor store?
probably vodka.
And then where'd you go from the liquor store?
So William called me while I was at the like when I first got to the liquor store, I had just parked, and he called me back. So I sat in the car and talked to him, and I was screaming and crying. She's gonna take my baby.
When you got back home after the liquor store run, was there some point that Ms. Franklin came to your home?
Yes, I was hysterical when I talked to Kate as well. So she came to my house and she spent the night. My apartment.
Did you speak to Adidion again that evening?
I did. I asked her to write an affidavit to the effect of the judge saying she was going to take Cadence and give her to her dad. Now, I think maybe I left out that in the first conversation, I said that I have to tell Kate and William. And can I testify to what Adidion said?
Yes.
And Adidion said that she didn't want me to do that. Because she didn't want to be in it, so she didn't want me to name her. Well, she didn't say she didn't want me to name her. She just said she didn't want me to do that. She didn't tell me for me to go back and tell my lawyers. And I promised her that I wouldn't name her. And that's how I got her to agree that I could talk to my attorneys about it.
Okay.
So I talked to Kate and William, and when I got home from the liquor store, I called Adidion again. I asked her to write an affidavit. She said no. I turned her on speakerphone. I can see Kate sitting at my island because I was sitting in a chair right here. My island is here, and Kate was sitting at the island. And I told her, I begged her to write an affidavit. I said she's gonna take Cadence. She knows who my child is. She loves my child. She said no. She cursed me out. She said no.
At some point after that evening, did you become aware that what happened had been reported to the JQC?
Yes.
Okay. Did you report it to the JQC?
No.
Why?
I mean, no disrespect when I say this, but I have very little faith in the JQC. I dare not speak for most or other attorneys, but I've been practicing for nearly 20 years, and it would never be my thought to contact the JQC. I think the JQC is for show.
Wait, you both panels, you think?
I plead the fifth.
Okay.
I don't know.
How did you feel when you found out this had all been reported to the JQC?
On one hand, I was relieved because I think that but for, in as much as I think that the JQC is for show, or I have historically thought that the JQC was for show, I think that but for the JQC's interference here, my daughter would not be with me right now.
Did you initially want to speak with a member of the JQC?
No, not at all. No, I didn't. I think you guys might have contacted me, and I wasn't willing to talk at first. William and I ended up in a lunch at a restaurant with you, and William facilitated that, and that's how it came to be that I talked to you. And then you said you'd subpoena me. So I didn't have a choice.
And then after that point, did you appear at an investigative panel meeting and make a statement to the investigative panel?
Yes.
Why didn't Kate file the motion to recuse Judge Williams? I'm sorry, Ms. Franklin.
She didn't want to file a motion to recuse and then the judge not recuse, and she still be my attorney. In the same way that I didn't want to file a motion to recuse because the judge would still, if she chose not to, she would still be the judge presiding over my case. So she thought it best that we have someone else.
And Judge Williams eventually recused from your case?
Yes.
Okay. What do you think should happen as a result of all of this?
Objection, relevance.
What's the relevant, are you talking about like the appropriate sanction, Ms. Beal, or what are you asking?
Yeah, I mean, I'm asking, well, you know what, let me ask it. I'm sorry, I will withdraw that question. Let me ask you two other questions. Did it become publicly known and well known that you had filed a motion to recuse Judge Williams?
It did.
Okay. And did it become publicly known and well known that you had eventually spoken with the JQC?
Yes, it became very well known very quickly. It spread like wildfire.
Okay. And what impact,
Objection, relevance.
Overrule that objection.
what impact, if any, did you see as a result?
So before I even filed the motion to recuse, I went back and forth with myself about whether or not to do that. I didn't sleep most nights. I effectively was having to decide between my child and blowing up my business that had just really taken off, and I'd been practicing for as long as I had. Because, like I said, if the judge didn't recuse, then she was still going to be on my case. The JQC's involvement became an issue because I guess I am on medication. I was talking to my therapist quite frequently at that time. And this is before I made the decision to contact the JQC, or not contact the JQC, to file the motion to recuse. I was terrified that I was going to blow up my life. And I would die 1,000 slow and painful deaths for Cadence, really and truly. I'm also her only source of financial provision, or I was at that time. And blowing up my business also meant that I might not be able to take care of her. I mean, there were so many other, there was so much collateral damage, I felt like, with filing a motion to recuse, with getting the JQC involved. I went from making pretty close to $500,000 a year to making $181,000 in 2024.
Did you, after all this blew up, if you will, did you continue to be appointed as a guardian ad litem by Fulton County Superior Court judges?
Sometimes, but not nearly as frequently. I could see a difference in at least one judge. Yeah, I don't even do guardian work anymore, and I loved it. I loved it. I was very good at it, but I don't do it anymore.
Why?
I'm not very good at it anymore, I don't think. I just really don't have faith in the judicial system anymore. I don't want to practice law. I practice law because I have to. That's how I feed my baby. I hate everything about it, if I'm being very honest.
If I could have one moment, please.
Sure.
All right, Ms. Alexander, I don't have anything further for you at this time.
Cross-examination.
Thank you. Just have a moment.
Good afternoon, Ms. Alexander. How are you?
I'm okay. Thank you for
Good.
asking.
My name's Gabe Banks, and I, along with Ms. McFadden, have the pleasure of representing Judge Williams in this case. And I do have several questions for you about your testimony. Okay.
Sure.
Do you recall me calling your office to try to speak to you about this matter and leaving a message for you?
I don't.
Okay. You never got the message?
I can't say that I didn't get it. I don't recall.
Okay.
Um,
Not saying I didn't call, did you?
no.
Okay, fair enough. Had you have gotten it, would you have talked to me?
Probably.
Okay, all right. Prior to today, how many times have you talked to Miss Veal?
To who?
To Miss Veal, Director Veal?
Maybe 3 or 4.
Okay. Certainly talked during the interview of the investigative panel, true?
Yes.
Did you talk to her prior to that?
So I'm sorry, I'm not counting when I testified. Are you counting that?
Sure.
Okay. Yes, I did talk to her prior to that. So if I count today when I'm testifying, then I'd say maybe 5 or 6.
Okay. At the time that you were interviewed by the investigative panel, while Ms. Veal was doing the interviewing, Chuck Boring was the then director. Do you recall that at all?
I'll take your word for it.
Okay. Did you have any conversations with Mr. Boring specifically prior to your interview with the investigative panel?
Not that I can remember.
Okay. All right. Let me ask you, how old is your daughter?
Now she's 12.
Okay. And back in 2021, she would have been
9.
9-ish? Okay. And you met the father of her child when?
2005.
Okay. And, you know, I'm a lawyer, so my math isn't altogether well. Having said that, what year was your daughter born in?
2012.
Okay. And you and the father of her child were in a relationship?
Yes.
Okay.
Off and on.
Okay. And was that relationship a distance relationship?
For a little while. We never lived in the same state while we were in a relationship. He was working on his PhD in Missouri, and I was practicing in Atlanta. And then when I got pregnant, I moved to Florida because I don't have any family up here. And he was in Missouri.
And were the two of you living together there in Florida at the time?
No. We
Okay.
did live together in Florida, but that was after he finished his PhD, and that was only for like a month.
Okay. And what years were those?
So I moved back to Atlanta in 2014. So are you asking when we lived together?
Yes.
That was 2014, for a month in 2014.
Okay. Only for a month?
Yes.
Okay. What made you, or what caused you to make the decision to move to Atlanta?
I was at the public defender's office in Naples, and Sharice, well, I won't say what she said, but I got a call from, well, let me say this. I was terminated from the Naples public defender's office.
For what reason?
I don't know that they gave one. I know I hired an attorney because of that, but I don't know.
That's not the only job you've been terminated from, is it, ma'am?
No, I was terminated from the Manili firm.
And from what firm?
The Manili firm.
For what reason?
They said, and I quote, "This is personal, not business." This is Michael Manili. He said that I come into the office, I do my work, I don't talk to anyone, I don't go to lunch with anyone, and then I go home. And his firm was more of a family-centered firm, but I was the mother of a young child, so I really did just that. I also believe Sharice had just left the firm, and they thought that I was giving Sharice information, but that's not what he said when he terminated me.
Fair. But at some point, when you moved from Florida to Atlanta, had your daughter been born at that time?
Yes,
Okay.
she was almost 2.
Okay. Were you still off and on with the father of her child?
I think he would say so.
Okay.
But no, he did come and stay with me for a week early on because Cadence got sick. I was in trial at the Manili firm for a week, so he came and stayed in my guest room to take care of her.
Okay. At some point, when did you terminate your relationship with the father of your child?
While I was pregnant.
Okay. And since that time, it's been, would you agree with me, a very contentious relationship?
Absolutely.
During the proceedings involving his petition to modify visitation, you had evidence that he physically harmed your child. Is that true?
I had evidence in the way of just someone being able to say that they heard my daughter say it. I didn't
Sure.
have direct evidence.
Okay. Had he ever been physically abusive with you?
Yes.
Okay. And in fact, at times when he would have her during visitation, you were so concerned with him having her that you placed a tracker on your child. Is that true?
Your Honor, I'm going to object at this point. I understand the panel is going to give some leeway, but this is not a retrial of any of her personal matters, and I'm not seeing how this line of questioning is relevant.
Sure, I understand. So it all goes to bias and credibility about the issue of recusal and whether or not she was going to ask for recusal and whether or not she was going to contest the proceedings that he had filed a motion to modify his visitation.
I think we can
rights.
ask her that question. I think going way far back about what happened and trackers and domestic abuse that may or may not have happened, I think we're getting way far afield. So I do sustain the objection to relevance as to that question.
Is it fair to say, ma'am, that based upon your history with the father of your child, that you contested his petition or modification for visitation? Is that fair to say?
Yes.
And that petition was filed in September, true?
Well, let me, if I may. We initially, when we first got served, we initially said he can have what he wants because the court would likely give it to him. We made that offer. They said no. So then it became contested, yes.
Right. He can have what he wants, but there was a list of things that you wanted him to satisfy. Is that fair?
Yes, we did send him a list. I don't remember what was on it.
Fair enough, but he didn't agree with the list, and so
Right.
it became a contested issue. True?
True.
And you didn't want to give him what he wanted without your conditions. Is that true?
I'm going to object again on relevance grounds.
Okay. I'm moving on.
Okay. Well, then let's move on.
Okay. And so at some point, your case, you hired a lawyer, Kate Franklin, true?
Yes,
And she had been your lawyer for quite some time. Is that true?
that's correct.
And at some point, you guys responded to the petition, and eventually the case was assigned to Judge Williams. Is that true?
Yes,
Okay. And it's your understanding that you wanted, because you didn't want your dirty laundry aired in the Fulton County Courthouse or before a sitting judge, you wanted to have a senior judge assigned to your case, true?
yes. I didn't want it to be heard before judges that give me guardian cases.
Fair. That would have been true whether it was assigned to any judge. Is that fair?
Absolutely.
You knew prior to the petition being filed that, at least in your mind, that Judge Williams had a reputation of being a father's judge.
I did.
And that concerned you as well. Did it not, ma'am?
I'm sure, yes.
Sure. You had a very contentious relationship with the father of your child. You didn't want him to essentially it was a contested issue, and you wanted to be in front of a favorable venue. Is that true?
I was not judge shopping, no.
Not saying that you were, but it's an
I
issue
wanted-
that concerns you, is it not, ma'am?
I wanted to be in front of an impartial judge who cares about the best interests of children and doesn't side with moms or dads, yes.
Okay. And at some point, you eventually, your lawyer, with or without your consent, eventually called the judge's chambers to try to figure out what the protocol was concerning getting a senior judge assigned to your case, true?
Yes,
And you don't know what date that was, but it was sometime in October, is that fair?
I'll take your word for it.
Okay. And after, did Attorney Franklin call you after she made the call to Chambers to let you know that she had made the call?
I think the first time I knew anything about the call was from the judge.
Okay. So Attorney Franklin makes the call, true, and then you get a call from the judge. Is that how it kind of played out?
That's my recollection,
Okay.
yes.
But you knew that Attorney Franklin was going to make the call before she made it. Is that fair?
Yes.
Okay. And, okay. You agree with me, and I think you agreed with it on your direct testimony, that getting a call from a judge on your cell phone was not uncommon. True?
Yes, I agree with that.
Happened all the time for you as a Gale. Is that true?
It happened often, yes.
Okay. Did you read the allegations and the formal charges in this case?
They were sent to me. I skimmed them. I did not read them in any great detail, no.
Okay. Did you see the references in the formal charges during your skimming as it concerns the judge calling you on your personal cell phone?
I probably saw that.
Okay. There's nothing nefarious about you receiving a call from the judge on your personal cell phone, right?
No.
Nothing about that in particular that made you feel uneasy, true?
No, not initially.
Okay.
I mean, yes, that's true. Not initially. I did not feel uneasy. I hope I answered that right.
And my understanding is that at the time the call was made, you had been renting space from Don Smith, true?
Yes.
You were renting a suite from her, true?
I was renting a side of her building,
Okay. And where is that located?
Tucker, Georgia.
Okay. And was your side of the building on an upper level or lower level? Do you recall?
It was lower level, and Dawn had the other side, and she had both upper and lower on the other side.
Okay. Someone else was renting out the space above you on your side?
No, someone rented the space below me.
Okay, fair enough. And at the time that you received the call, my understanding is that you were not in Don's office, true?
Yes, I was next door. So Dawn's office would have been here, and then she had an empty office where they sometimes put storage, and then right next to that was her associate's office, and I was in her associate's office.
Okay. So in terms of, you motioned with your hands that there was an office between Don and the associate's office, true?
Yes,
Okay. And
I think so, yes.
about how far would Don, if that's Don's office underneath the screen, if that's the entry of Don's office, how far would you walk to get to the associate's office? Vice versa.
Okay, so if that was the associate's office,
Mm-hmm.
maybe like to either where that computer is or the Purell.
And when you say the computer, are you talking about the computer on the desk in front of the court reporter, or are you talking about the computer screen on counsel's table?
The former.
Okay, so on okay, all right. Do you recall what time it was when you received the call?
No, I'm sorry.
Okay. When you were in the associate's office, was the associate in the office at the time you received the call?
Yes.
What was the associate's name?
I want to say Tammy.
Was she white?
No.
Okay. And what ethnicity was Tammy?
Black?
Okay. And how old was Tammy? Do you know?
I have no idea, but at least I thought of her as a baby lawyer at that time.
Right. Did you know how long she had been practicing law?
I'm sure she told me at some point, but I don't remember.
Do you know what you were doing in her office at that time?
Probably just talking.
Sure. And at some point you get the call, true?
Yes.
You certainly answer it, right?
Yes, I answered it.
And my understanding is what you said is that the judge told you, according to your testimony, is that, we got a call from someone who claimed to be your lawyer, and we wanted to make sure if that was true or not. Is that, in a nutshell, what she initially said?
Yes, she said that they got a call from someone claiming to be my lawyer saying that I wanted a senior judge to overhear my case. And she wanted to know why I wanted a senior judge to hear my case.
Okay. And you told her that you were embarrassed.
She asked, and I said yes.
And did she say anything else? I mean, before, when she first made the call, do you remember specifically what the first thing was that came out of her mouth?
I'm sorry, I don't.
Okay. But I'm assuming within seconds of the call, the judge said, hey, we got a call from a senior lawyer.
Very
Or
early
someone
on.
who claimed to be your lawyer, true?
Very early on, yes.
Okay. I'm trying to get a feel for if before her saying that, there was any exchange between you and the judge in terms of exchanging pleasantries or whether you talked about anything else.
I don't remember, but I would imagine there were pleasantries.
Okay. And so, but within certainly seconds, moments, minutes of, do you know how long the call was?
I don't.
Okay. Did at some point you check your phone records?
I did go back and look to see when the call was prior to the IP hearing.
Okay. And were you able to discern when that happened?
At that time, yes, but I don't now
Okay.
remember.
Did the records reflect the duration of the call?
I would think so.
Okay. Do you recall as you sit here today how long that call was?
No, sir.
Okay. And at some point, very early on in the call, you would agree is when the judge, according to you, said something to the effect that my J.A. or Janelle told me that I shouldn't make the call because it's ex parte, but you said that at some point it's on the shield. Is that true?
I didn't say it was on the shield. That's what the judge said that she told Janelle.
Sure. Okay. And was that at a time you were still in the office of the associate?
I don't remember.
Okay. And you said on the shield means swear?
No, I said it's like, I don't really know how to describe it other than to say it's like a swear. But I don't know how to
It's like a what,
describe
I'm
it.
sorry?
Like a swear.
I swear.
Okay.
Like, I would never tell anybody that on the shield.
Okay.
Is that something you're, a phrase that you understood or that you have heard before?
Yes.
Okay.
Have you ever heard that phrase from the judge before?
No.
Okay.
Not before that day.
All right. Did you know the judge was in the same sorority as you?
Yes.
And when did you find that out?
I have no idea. But when we get new judges on the family bench, it flies around pretty quickly, the information about the judge. And
Okay.
because they change every 2 years, give or take, the family bench in Fulton.
Prior to, did you pay particular attention to the campaign that she ran at all?
I didn't.
Okay. Did you support Rebecca Reeder in her bid for re-election at that time?
I did vote for Judge Reeder.
Okay, fair enough. Did you contribute to her campaign?
Not that I can recall.
Okay. Did you know that then candidate Williams was opposing Judge Reeder?
When I voted for her?
No. Yeah, when you voted for Judge Reeder, true?
Yes.
You
So yes,
can't-
when I voted for Judge Reader, I knew that her opponent was Judge Williams.
Okay.
Does that answer your question?
It does, it does. At some point, though, did you find out that the judge was in your sorority after, the election was over with?
I'm sorry, I don't know when I found out that we were in the same sorority.
Okay, all right, fair enough. All right. Something in the call caused you to, at some point, go to Don Smith's office.
Very early on, when I knew that the judge was talking about my case.
Okay.
Yes.
It would have had to have been after the comment about Janelle, because that happened early on in the call, true? And that's when you first told her that, hey, it's about my case, true?
I can't say I don't know when I got up to go to Don's office. I don't know what the judge was saying at that time. I'm
Okay.
sorry.
All right. And so what was it about the call that caused you to go into Don's office?
Like I said, I thought if this becomes a thing I guess my intuition just told me to go and have Don listen to it in case I needed somebody to say, yes, this call did actually happen.
Okay. And you wanted to make sure that it was a white woman that ultimately listened to the call to give you credibility?
Well, it's not that I
And I'm not suggesting that white women aren't credible. I mean, Judge Burleson, I wasn't suggesting that, but I'm just trying to get your psyche and why did you want to make sure that it was a white woman?
I didn't say I wanted to make sure it was a white woman. I said that Dawn is a white woman and a prominent attorney in family law in Atlanta, and therefore I felt like she would be a great person to have listen to the call. Also, Dawn's entire legal staff being attorneys were all black. Mm-hmm. So, yeah, if Dawn was a black woman who had been working for as long as she had in Atlanta and had the reputation that Don Smith has, I still would have thought better of that than me by myself having the call.
Sure.
Does that make sense?
Sure, it makes sense, I think. Did you think about recording the call at all, ma'am?
I didn't. I'm not tech savvy. I'm the least tech savvy person you know.
Okay. But you go in to Don Smith's office, and at some point, when you go in, is the phone on mute, or is it on speakerphone off of mute?
I don't remember. I just know that I pointed to the phone and I mouthed to Don.
Okay. And do you recall whether or not you were in Don Smith's office when the language on the shield was used?
I'm sorry, I don't.
Okay. Did she ever ask you after the conversation what on the shield meant?
Maybe. Dawn was very intrigued by the sorority piece of it, so she may have asked that. I don't know.
Okay. Was Don Smith in the room at the time the judge referred to you as Sora?
Well, the judge said she referred to me as Sora on a number of occasions in that call, like more than once. I won't dare to guess how many, but more than once. So at some point, Don did hear her say Sora.
And when she referred to you as Sora, tell the hearing panel in what context it was.
Like I said, she said Sora a number of times. I don't know. She never said Brandy. So I don't know when she said Sora.
Okay.
I wish I could help you with that. I'm sorry.
All right. You do recall, however, that at some point, ma'am, she never talked about the merits of your case. Is that true, ma'am?
No, we didn't actually. I didn't bring up my case. So she asked about my case. She asked why I wanted a senior judge. She asked if I was embarrassed. I said yes. I did not give her any information about my case because I didn't think that proper.
Sure. Beyond asking about, whether you wanted a senior judge or why you wanted a senior judge, she didn't ask you about any specific details concerning what was going on between you and the father of your child, true?
Not to my recollection, no, she didn't ask that. I do remember feeling like she wanted me to tell her, but I didn't tell her. I don't know if she said something to make me feel that way or if I just felt that way. I don't know that part.
Whether you felt that way or not, you would agree with me that the details of what was going on between you and the father of your child and the merits or the substance of his petition and your opposition to the same was not discussed during that conversation. Is that fair, ma'am?
Yes, it is.
Okay. And she also didn't tell you how she was going to rule. Is that
I'm
true?
sorry.
That's
No,
okay.
she didn't tell me how she was going to rule.
Okay. At some point, the call ended. True?
Yes.
Did you stay in Don's office for a while?
Probably.
Okay.
I'm sure I debriefed with Don.
And what did the two of you talk about?
What just happened on the phone?
Sure.
I can answer that very generally. I can't really answer it specifically.
Okay.
So that's the answer. What had just happened with the phone call with the judge. That's what we talked about.
All right. And what did she say to you? Do
Who,
you recall?
Dawn?
Yeah.
I have no idea. I know that Dawn was really like, she thought the judge calling me soror was an issue.
Okay.
That's all I remember about the conversation with Dawn.
Did she encourage you to file a complaint?
I think so.
Okay. And what was your response?
Again, I don't actually remember, but you saying, did she encourage me to file a response? I vaguely feel like she did. I'm sorry, I don't know the conversation with Dawn. I just don't.
Had you ever had a conversation with a judge like that before?
No.
Okay. So you know some details, but don't know specific details. Is that true, ma'am?
I know specific details about specific things
Okay.
in that conversation, but my conversation with Dawn, no. Just like I can't tell you what I was talking to Tammy about either before the judge called. I have no idea.
Did she tell you to file a motion to recuse?
Dawn?
Yeah.
That's possible.
Did you talk to her
Maybe even
about
probable.
filing? I'm sorry?
I said maybe even probable. I said it's possible, maybe even probable.
Did you?
But I know that at some point we did have a conversation about a motion to recuse. I don't know if it was on that day, and I don't want to lie.
Fair enough. All right. Eventually, you called your lawyer, Kate. True?
Yes.
And that is at which point you and Kate did have a conversation about getting the judge off your case. True?
Yes.
You indicated to the hearing panel during your direct testimony that you did not want to do that because you felt that there would be some backlash. True?
Correct.
It's not that you didn't want the judge off your case, it's just that you felt that there would be some backlash if in fact you filed a motion to recuse. True?
Yes and no. I didn't necessarily love the idea of the judge being on my case, but I also didn't want to file a motion to recuse because I thought there would be backlash.
Okay. Did any of the issues of her being a father's judge come into play in that decision to file and or not to file a motion to recuse thereabouts in October of 2021?
No, my biggest issue with the motion to recuse was how it was going to affect my business. It had very little, I mean, I don't want to say that it had her being a father's judge had no impact on me at all, because that would be untrue. It absolutely did make me feel away. But my issue with filing that motion to recuse was I'm just getting to a place where my business is doing well, and now I'm about to implode it. And that was terrifying for me because I'm living in Midtown, I'm paying a lot of rent. I mean, I think I answered your question.
Fair enough. And then at some point after that conversation, You then, while represented by Kate Franklin, go to, is it the status conference in December of 2021?
It was noticed as a motions hearing,
Mhm.
but yes, it was a status conference.
At
And
that,
that was even an issue because Kate wasn't sure.
which it was.
I'm sorry?
What type of hearing it was?
Right.
Okay. And you guys appeared on December 14th of 2021, true?
I'll take your word for it.
All right. And at that hearing, Judge Williams brought up the issue that you were a Gale in her courtroom, true?
Yes.
And eventually, the father of your child, through his lawyer, Ms. Connor, said that he wanted to recuse Judge Williams. Is that true?
Yes.
And he was very concerned about the image that Judge Williams had of you and the fact that you served as a Gale in her courtroom, true?
I can't speak to what he thought. I know that his attorney said that she thought that because I was a guardian in front of Judge Williams, that it would be best to recuse, to have Judge Williams recused. I'm sorry.
That would have been a perfect opportunity, you would agree with me, ma'am, for you to, through your attorney, to agree to the recusal, true?
Absolutely. Absolutely. Hindsight is 2020.
But it's not just hindsight, because at the hearing through your attorney, you objected to the recusal, true?
Yes, I think so.
You didn't, I mean, you could have left it to the court's discretion, but instead, you, through your attorney, objected to the recusal, true?
Yes, but that was not a conversation that my attorney and I had. So we were on Zoom. My attorney objected. Did I say, no, Kate, don't object? No.
Did you ask for a breakout session?
I did not.
To talk to your attorney about her position concerning recusal?
No, sir.
Okay. And at that time, you still felt there was a large part of you that wanted the judge recused from the case, true?
Yes, I was torn, but yes.
Torn, had an opportunity to get a recusal or at least join in the recusal with another party, but you didn't do that, did you?
I did not.
Sure. And then, ma'am, you showed up at another hearing on January 13th of 2024 or 2022. I believe that's the date.
I do remember January 13th.
Sure. And that was the temporary hearing in your proceeding, true?
Yes, sir.
And at that hearing, you did not object to Judge Williams staying on the case then either, did you, ma'am?
No, we didn't do anything ori tennis in the way of objecting.
And, and that hearing didn't go well for you, did it?
I don't think so. No, it
I
didn't.
mean, you walked away feeling like this is going to be bad for me, true?
I walked away feeling like this was going to be bad all around.
Right.
So it wasn't, and I know where you're going with this.
Well, I don't want you to think about where I'm going. I just want you to answer the questions.
Okay, so my answer is that, yes, it was a bad hearing. Did I worry that the judge was going to be a father's judge as my judge? Absolutely. But more to the point, I was concerned about how she was acting on the bench. Like things like throwing a pen, eating from the bench, not letting the psychiatrist go tell her her patient that she was stuck in court and would be a minute. That sort of thing was problematic.
Okay. You
And
ever
if I
been a
can-
judge before?
Your Honor, I'm going to object and ask that she be allowed to finish.
Okay, I wasn't trying to
I don't
interrupt
think it was
you.
intentional,
No,
but
it
yeah,
wasn't.
try not to step on each other.
Absolutely.
If I'm being very honest with you, part of me did think, because of that ex parte hearing, maybe she was gonna, rule in favor of me. But the bigger part of me, as an attorney, was concerned with her general actions. And if she's acting like that with me, what is she doing with people who don't know any better, who don't know the law?
You were primarily concerned after that hearing, would you agree, ma'am, with your daughter and how this was going to impact your daughter, true?
I'm concerned, yes. I am concerned every minute of every day with my daughter and how things impact her.
I understand every minute of every day. You're a mom, like most moms and dads who have kids. They're concerned about their kids every day, every minute of every day. But after this hearing, it's particularly true because you were contesting what the father of your child desired in this case, true?
Yes,
Okay. And you didn't file a motion to recuse until it started to go south at that second hearing, true?
I filed the motion to, yes, I filed the motion to recuse after the temporary, and after I learned that she would have Cadence yes, that's the
Okay.
answer.
And so I'm interested because at some point, Kate indicated that you needed to report the matter or file a motion to recuse, true?
She said we had an ethical obligation to report it, yes.
Okay. Did you talk about recusal with
With
Ms.
Kate?
Franklin? Yes.
Yes,
Okay. And so she was your attorney at the time, true?
yes.
She had been your attorney for how many years now?
I don't do math just like you, so 2016.
Okay.
Give or take, 2015, 2016, we established an attorney-client relationship.
Okay. Why didn't she file the motion to recuse? Why did you hire another lawyer to do that?
I didn't technically hire him, he was pro bono, but Kate didn't want to be the person who went before the judge on a recusal, and then the judge didn't recuse, and then she was the attorney handling my case for the duration.
Were you familiar with William Alexander's firm prior to 2021?
Yes,
Had you done any work for him or with him?
we have been co-counsel, me as the Alexander firm, him with, at the time, Richardson, Bloom and Lyons.
Okay. And did you have his personal cell phone number in your phone?
Yes.
Okay. How did you contact William Alexander to help you with this recusal? How did that come about?
Again, William and I had 2 conversations about recusals. I don't remember when the first one was. I only know that I was in Florida standing in the back of my mom's house outside. And then the next conversation was when I said, okay, William, you can file the motion to recuse.
I'm sorry, I missed it. When did you reach out to him or did he reach out to you?
The first time we talked,
About
like when
the-
I was at my mom's, I don't even know why we were on the phone that day, but we ended up talking about judges and how crazy things are right now with judges. And so my case with Judge Williams came up, and he said, if you want to file a wait, I'm sorry, you said I couldn't say what Williams said, but that's when we had that conversation.
Okay. And you indicated that he represented you pro bono?
Yes.
Okay. Why did he do that? Do you know?
He offered, I accepted.
Sure.
He's,
Okay. You were making good money at that time, were you not?
I was.
Was it strange to you that he offered to represent you pro bono?
Not at all. He didn't know how much money I was making. He knew that I wasn't making great money before that.
And at some point, Mr. Alexander assisted you in preparing a motion for recusal, true?
Yes, he drafted it.
And at some point, an affidavit was prepared for your signature, true?
Yes.
And during the course, did you draft that affidavit or did he draft that affidavit?
I'm sure William did.
Okay. You provided him the details to insert in the affidavit that you ultimately signed it off on, true?
Yes.
You certainly wanted to be thorough in your affidavit concerning the motion to recuse. Would you agree with me, ma'am?
I don't know. Well, I guess so, yes. I don't know. I still don't know anything about affidavits and recusals. I just know what William told me he needed. I gave him that information.
Sure. But at the end of the day, to the extent that you're going to file a motion to recuse, you want to make sure that it sticks so that the judge is no longer on your case, true?
Of course.
You would agree with me, the more details you provide in an affidavit, the better off or the stronger that affidavit would be, true?
No.
You don't agree with that?
No. I wrote an affidavit in Henry County for a TPO. I was extremely detailed against my daughter's father, and that hurt me. So, no, I don't agree with that.
Okay.
But I think that sometimes, yes. But
Well,
for me, no.
Okay, so in this case, did you think that it was important to provide context and details about your conversation with Judge Williams and any other issues that you felt would give rise to recusal, ma'am.
Yes, I thought that whatever William asked me to provide, I needed to provide. So that's why we included those affidavits or the information about Nigel and Brandy.
What did you do to prepare for this hearing today?
Prayed and cried.
Did you review any documents, ma'am?
I did.
And what did you review?
My transcript from the IP hearing.
Okay. And did you review the motion to recuse?
No,
Did you review your affidavit?
no.
You understand that your affidavit was filed on January 24th of 2022.
I'll take your word for it.
Okay, I don't want you to take my word. I want to show you a document. I'll mark it as Respondent's Exhibit Number 2. If I may approach.
Right.
Take a look at that.
Sure.
Let me know, ma'am, if you recognize that document, and if that confirms in your mind whether or not your motion for recusal was filed on January 24th of 2022.
It's date stamped January 21st, 2022 at 3:40 p.m.
Okay. Obviously, if you turn to the signature page on page 8, it certainly has a signature line and a date of the 24th as well. True?
Yes.
All right. If I could just have a moment. Can I have a quick comfort break?
Sure.
We've been going for a minute.
Okay. Why
Can
don't we
I-
take a 10-minute recess?
Okay,
Okay.
thank you.
Sure.
May I proceed, Your Honor?
Yes, sir. Go
Thank
ahead.
you. Ms. Alexander, I think when we left off, I asked you to verify the date that your motion to recuse was filed. Did you verify that date as January 24th, 2022?
I did.
And we were talking about making sure that your affidavit provided detailed information to ensure that your motion to recuse was successful. Do you
Yes.
recall that? Have you had an opportunity to review your affidavit, ma'am?
I didn't.
Okay, do you want to take a look at it before I ask you questions about it?
Sure.
Is this what you marked as R2?
I did,
Okay.
and that's up there for your honors. I think it is also J3. I made the mistake of not paying too much attention to
It
the
is,
joint
yeah, it is.
exhibit.
Okay.
Having said that, I wanted you guys to have a copy.
The director's copy had a sticker, and yours just has.
I'm a poor lawyer, and so I need to make time to purchase some new exhibit stickers. Oh, you have some?
Good thing you're not under oath.
I didn't mean to embarrass you.
I would say I'm very poor compared to your standards. Just let me know when you're finished, and
I'm done.
are you done?
Thank you for your patience.
All right, thank you. Are you prepared to answer questions about your affidavit?
Yes, can I look back at it if I need to?
Absolutely. And so, in your review of your affidavit, ma'am, tell me if it's true, if this is a true statement. Nowhere in your affidavit attached to your motion to recuse, filed back in January of 2022, do you make any mention of Judge Williams saying on the shield, do you?
No.
Nowhere in your affidavit, ma'am, filed back in January of 2022 in support of your motion to recuse, do you make mention of Judge referring to you as Sora? True?
Yes, that's true. I did not make mention of that.
And in fact, you made no mention that you and the judge were in the same sorority. True?
Correct. Yes.
Nowhere in there did you make mention that the judge was going to take care of you, did you?
No.
You would agree with me, you believe that those are very important facts to raise in a motion to recuse, to express bias that a judge may have. True?
Sure. I mean, I didn't say anything about the sorority or the shield. I still don't even know if I should be talking about the shield that phrase publicly. That was never something that I was hanging my hat on. That was something that Dawn was very much intrigued by and saw as problematic.
But
What did you mean when you said you shouldn't be talking about the shield publicly?
So there are sorority secrets.
Well, did you take an oath of office, or do you take an oath to practice law?
Yes.
Do you have a higher duty to some sorority than you do to the law?
Well, that's why I'm talking about the shield now.
But, okay.
But to his point, you didn't talk about it when you filed your motion to recuse, did you, ma'am?
No.
And you're saying your testimony is that you didn't talk about it because you felt like you shouldn't publicly talk about it?
I don't know why I didn't say anything about it. I just know that this whole thing this being the JQC trial and former hearing, made a bigger deal about the sorority than I ever did or thought to.
Okay.
Because tons of judges are deltas.
Sure.
Tons of judges are AKAs. Tons of judges are zetas. Like, that's just not something that, for me, was a huge deal. It was a huge deal for someone else.
Well, not just for Don Smith. You would agree with that, ma'am. It was also a big deal to you, true?
That she called me a soror? No.
Or that she said on the shield?
That wasn't a big deal to me. That just meant that she was saying that she told her, I guess Janelle was the staff attorney, who was also a soror and would understand what that phrase meant, that it wouldn't go any further. That's all I took that to mean. I didn't put a whole lot of weight on anything related to the sorority.
Did you qualify those remarks, ma'am, that you're making now to the JQC when you appeared in front of the investigative panel, when you testified about that she said it was on the shield? Did you qualify those remarks then?
They didn't ask me about that in the way that you have, so no, I didn't.
Okay. You thought it important enough in June of 2022 to testify before the investigative panel under oath, ultimately, that Judge Williams said on the shield. True?
I believe I was asked about it, but yes, I said it at that time.
That's been about 1,070 days ago. Is your memory better then or now?
Then, for sure.
Well, to that end, your memory was better in June of 2022. You agree with that, right?
Yes.
Was your memory sharp in January of 2022 when you initially filed your motion to recuse?
It was, and I did not put that in there for reasons that I've already stated.
You indicated that you were concerned about some of the judge's conduct during the January 22 hearing, true?
Yes.
And did you have authority to take pictures of the proceedings?
We're
in
told
your
not.
case?
We're told not to video record.
Okay. Did you have any permission to take pictures of the Zoom proceedings?
No one gave me permission or told me not to take a picture. No.
Did you file a Rule 22 to take pictures of the Zoom proceeding?
I don't even know what that is, so I'm going to say no.
Okay. You understand, how long you been a lawyer?
Nearly 20 years.
And here in Georgia for how long?
So I was barred in 08. I started practicing here in 09, whatever the math is on that.
Okay. And at some point during that stint here in Georgia, you certainly understood that you had to have permission to take pictures and record proceedings inside the courtroom, true?
Yes.
You didn't seek that permission in your hearing, did you, ma'am?
No.
Okay. At some point,
God bless.
where was this picture at?
I'm sorry?
Where's the picture?
I don't have it anymore. It's on a phone that is broken and yeah. I
So
don't
you
have it.
just, did you send it to anybody?
My mom.
Okay, does she have it?
I doubt it. She doesn't even have the pictures that she took in my delivery room.
If you're going to accuse a judge of misconduct and about eating in the courtroom and stuff like that, why wouldn't you just keep the picture, man?
Well, apparently I wasn't supposed to take it in the first place, sir.
Well, you didn't know that.
I didn't.
Was
Okay.
the picture by text or was it on this thing?
Yes, sir.
Did you give the director your cell number where they could subpoena those text messages and get the pictures?
I don't know that they asked for my cell number at the JQC, but they do have my cell number.
Okay, thank you.
At some point, ma'am, you had a conversation with Adidion Aaron. Is that true?
Yes.
At that time, Adidion Aaron was a friend of yours, true?
Yes.
Would you say close friend?
I would say so.
Okay. And eventually, you told her about your conversation with the judge, true?
Yes.
And she actually texted you and let you know that she was speaking to the judge, and the judge was talking about your case, true?
Yes.
At some point after all of that, you then came to the JQC and to others, and you told them that Adidion told you that the judge said she was going to show you because this was personal. She was going to teach you a lesson and take your daughter from you and give it to you, the father of your child. True?
That she was going to show me personal when she took my daughter and gave her to her dad. Yes.
Okay. All right. And in fact, that's not what she said, is it?
I wasn't on the call. I know only what Adidion told me she said.
Okay. That's not what Adidion told you that the judge said, is it?
It absolutely is.
Okay. And at some point, Adidion confronted you about why you said she said that, didn't she?
I won't say she confronted me. We talked recently, and she asked what I planned on testifying to.
Okay. I'm talking about back at the time that this was all going down. Did she ever confront you and say, why did you say I said that?
Not that I can remember.
Okay.
My first contact where we actually talked about everything was recently.
Okay. Do you recall her ever confronting you way back when all this was going down? Why would you say I said that? You don't recall that?
No.
Do you recall your response being to her, I have a bad memory, girl?
No. So she wouldn't have said to me back then, whatever it is that you just said. She wouldn't have said that because she stopped talking to me after I said that I needed her to do an affidavit. She was very upset. She stopped talking to me after that. And like I said, the first time that we ever, and she and I actually agreed to this on the phone, like we've never actually talked about what happened. So the first time that we actually talked about it was in the last, I want to say 2 weeks or so. And she asked what I was going to say. I told her, and at that point she said, I never said that. I never said that the judge said that she was going to take your daughter. And I said, yes, you did. And we went back and forth for a second. And I did say that my memory is bad. I said that, and to be honest, I don't have a great memory now that I'm old. But the fact is, I said it because I didn't want to keep, I didn't want us to start arguing again. We were finally in a place where it felt like we were okay. And I just didn't want to ruffle any feathers. So I said, I don't know if I put girl at the end, but I probably did because that sounds like me. But yes.
You were asked, ma'am, how this has impacted you, and you made reference to taking medication. True?
Yes, sir.
You were taking medication before this long ago. I mean, she said how this impacted her, and ultimately, it opened the door to explore whether she was on medication prior
Right.
to these events.
Within reason, I agree. So I'm overruling the objection for now, but let's just see where you're going with this.
Okay.
No.
You weren't on medication before?
No.
Okay.
I
Ma'am,
mean,
you-
not fluoxetine. No, not anything for depression or anxiety.
Okay. Ma'am, did you ever get terminated from the Clayton County PD's office because you lied and indicated that there was a client of yours trying to kill you, and that was determined to be a lie, and you got terminated, ma'am?
No, sir, I was not terminated from Clayton County. I left Clayton County voluntarily.
Okay. Well, I thought you testified earlier that you got terminated from Clayton County.
Naples, Florida. That was Collier County, Florida. And it wasn't for that reason. I've
Okay.
never had, I don't even know where you got that from.
Okay. At some point, ma'am, do you recall testifying that back in 2021 and in 2022, you were making approximately $500,000?
Not quite, but
But close to, right?
close to.
Okay, all right. Do you recall at some point after the father of your child filed for a petition and modification of visitation that you countered with a modification for upward in child support?
Yes,
Okay. And in that upward modification, you told the court that you were only making $14,000 a month, true?
I don't know. So if you have something tending to show that, then yes, but off the top of my head, I don't know what I said I was making at that time.
If I may approach.
You may.
I'm going to use a sticker that I see so I don't get chastised by Mr. Hyde. I want to show you, ma'am, copy what I will represent to you is a copy of the temporary hearing transfer that occurred back in January of 2022. You want to take a look at that?
I have it.
Okay. Okay. Ms. Franklin was representing you at that hearing, was she not, ma'am?
Yes, she was.
I want you to take a look at page 8, or you can start on page 7. And just to orient you, if you start on page 6, line 13, that is where Ms. Franklin is speaking, and then it extends onto page 7 all the way through page 8.
I'm sorry, what line on page 6?
Line 13, do you see where it reflects Ms.
Yes.
Franklin is speaking to the court?
Yes,
And she goes on and talks about some of the issues that are present between line 6 and line 7, or page 6 and page 7, true?
yes.
Okay, and if you could turn to page 8. Line 4.
Okay,
But we would be willing to concede his income even at what he states it is $12,800 a month. And with my client earning $14,000 a month, the child support should increase. Do you see that there, ma'am?
yes.
$14,000 a month is nowhere near $500,000, is it?
No. But
Were
we
you
later.
lying to the court through your representation of your lawyer about how much money you were making then, ma'am?
No, this was January of what, 22?
It was certainly January of 2022, prior to your motion to recuse, where you testified before this hearing panel that you were impacted so significantly that your salary dropped from $500 to $188,000.
Again, I never said I was making $500,000.
Close to it.
I said I was making pretty close to it.
I don't know what that means.
I don't remember the number, and
450?
I think it was closer to like 390.
Okay.
Wait a minute, ma'am. You telling this hearing panel that you said that you were making close to 500 in your direct testimony, and now you're saying it was closer to 390? Is
No,
that
I
what your
still think-
testimony is?
My testimony is that I believe it was closer to 390, and I think 390 is closer to 500 than it is to 100,000.
But certainly 400 is closer to 390 than 500, true?
Sure.
So are you changing your testimony of what you were making when you testified before the hearing panel so it more mask what you represented to the court back in January of 2022, ma'am?
My testimony is that I was making pretty close to $500,000. I stand by that.
Okay.
Assuming it was 390, that's pretty close to $500,000 to me. It takes maybe 4 or 5 more clients to get there.
Okay. But you didn't say 400,000, did you?
No, sir, I apologize that I didn't get closer to a number that you would have preferred.
You would agree with me that 14 times 12 is 168,000.
I don't do math. I'm sorry, I have an English degree.
Okay.
I'll take your word for it.
All right. 168,000 is nowhere near 390,000. Would you agree?
It depends on who you ask. If somebody said, Brandy, are you making close to $300,000 at $168,000? Depending on how many clients I would need to get there, I might say close enough, or I might say no. I don't know.
Are you still looking at the same transcript, ma'am?
I still have it up. I haven't looked down at it.
Okay, fair enough. You indicated that at some point you were concerned about the judge's behavior during that hearing because at some point your therapist, Dr. Sarah Vinson, true?
That was Cadence's therapist, yes.
Okay, but the therapist asked for a break and the judge wouldn't give it. Do you recall that testimony earlier before the break?
Yes, I do.
But that's not true, is it, ma'am?
That's what my memory is that she
Okay,
asked
well,
for.
let me refresh your memory. Why don't you take a
Can
look?
I finish my
at-
thought, please?
Yeah, you can finish.
That's all right. Go ahead. Ask your question.
No, finish your thought. I
No,
want you to know.
darling, you have the floor. Go ahead.
Okay. I want you to turn to page 111. I'm sorry. 112.
I'm there.
All right. And do you see line 19 where it says the witness?
Yes, I do.
And you tell me if I'm reading this wrong. The witness says, okay, can I just pause for a second and let my patient know, is that okay? The court's response, I don't know that she has a long list of questions. It's not 5 yet, but if you want to, sure. The witness, well, it's 4:59. The court, okay, sure, go ahead. Did I read that right?
You did.
Okay, and if you look at page 113, that's lines on page 112, that's lines 19 through 25 on page 112, true?
Yes, sir.
And then if you look at page 113, at the top of that page, ma'am, it says there's a pause in the proceedings.
Yes.
Do you know what that means?
Yes. We
Okay,
took a brief recess.
Okay, but you represented that at some point, Judge Williams, you had such a problem with her conduct and behavior during this hearing, and one of those issues was the fact that she wouldn't let your therapist take a break, true?
My daughter's therapist. Yes, I did represent that. I was clearly mistaken.
Okay.
I apologize.
Well, you lied. You weren't mistaken. You lied about that to this hearing panel, didn't you, ma'am?
Well, a lie I think is intentional, and I did not intentionally make the mistake.
Did you unintentionally misrepresent your salary, ma'am, to this hearing panel?
I don't think I misrepresented my salary. If they think I misrepresented my salary, I'm sorry.
Well, let's see what else you unintentionally did, okay?
Okay.
Did you at some point make a representation to this hearing panel, ma'am, that you were concerned about the judge's conduct because she wanted an ex parte with your daughter without, or an in camera with your daughter without anybody in the room? Do you recall that?
Yes, I said that she wanted to have, that we filed a motion for in camera, and the judge said that she wanted to have Cadence in there, and that Tangi said I shouldn't let her do that because of all the reasons I've already testified to.
I get it about the Tangi Bush, and we'll get to that in a minute, but I'm just talking about your representation that the judge represented during that hearing that no one else would be in the room other than your child. That's not true, is it?
If you're going to point me to the line and number page, sure, I may be mistaken. But my memory is that the judge said, I don't even know that we spoke about who was going to actually be in the room. I think that the first time I talked to anybody about who was going to be in the room, wait, let me remember. Okay, so the judge said that she would talk to Cadence in camera. I don't know if the attorneys brought it up or not, but somehow there was some communication about whether or not there would be, the attorneys would be allowed in the courtroom or in chambers. And the judge said no, that she's under no obligation to do that. And she cited whatever case she cited. Did I answer your question?
No, but I'm going to direct your attention to 152. Why don't you take a look at that?
What page? I'm sorry.
152 of the transcript. it says, "The court, no worries. I do not do in cameras with the counsel of the parties present. The only person who is present other than the child and myself is Madam Court Reporter." Do you see that?
I do.
So she wouldn't have been in the room by herself, true, ma'am?
She would not have been if she had taken a court reporter in, yes.
And in fact, there would have been a record of what your child said, true?
If there was a court reporter, yes.
And it would have been an in-camera proceeding, true?
Yes.
That record would have remained in camera unless and until the parties tried to move it out of camera, true?
Yes.
Okay, so you weren't telling the truth about the judge's behavior, saying that she wasn't going to let anybody in that in-camera hearing with your child, true?
I was mistaken.
I'm sorry, it was an unintentional mistake, right?
Objection argumented.
Yeah, that was. I'll withdraw that
Sustained.
question.
It's okay. I knew what he was doing.
Yeah, it was coming. When did you have this conversation with Tangi Bush, ma'am?
I'm sorry. I don't know a date.
Okay. Was it before your motion, the temporary hearing in January of 2022?
I don't know that either. I want to say it was after because, well, I don't know because we had already filed the motion for in camera, and Tangi and I talked a lot back then. So I don't know if that conversation was had after we filed the motion for in camera or after the temporary hearing.
And it's your representation that Tangi Bush, Judge Williams' former staff attorney, told you not to let your child go in there, true?
Yes.
And that the judge would weaponize this against you if you allowed your child to go in there, true?
Yes.
And that she would manipulate your child into speaking favorably about the father of her child, true?
I don't think I said the word manipulate, but give or take, yes.
Okay, what word would you use?
My recollection is that Tangi just said, don't let her talk to Cadence because she has kids say positive things about their dads, and then uses that as a reason to give the child to the father.
Okay. Where were you when this conversation took place?
You mean where in space and time, or like was I over the phone or in person?
I just want to know what your location was. Where
I
were
was
you
at my home
Okay, and where
over
was
the
Tangi?
phone. I don't know where Tangi was.
Okay, and did you call her or did she call you?
I probably called her, but I don't know for sure.
And how is it that you came to meet Tangi Bush?
I met her by way of her being in the position as a staff attorney.
Okay, while you were a Gale?
Gal, yes.
Okay. And did you guys ever go out with each other at some point during that time?
Not that I can recall.
You
We
ever-
just talked on the phone mostly.
Okay, and how often would you talk on the phone?
I don't know. It depends on what was happening in our lives.
Okay, once a week?
No, not that frequently. I don't know. Sometimes I would go a month without talking to Tangi on the phone. Sometimes I would talk to her once a week. It just really depends on what was going on
Okay.
at the time.
Would you be surprised if Tangi says she didn't say that to you?
No,
Okay. Same as what Adidion Aaron is saying. True?
I'm not surprised and I'm not upset with them for that at all.
Overruled.
If I can just have a moment.
Sure.
Sorry about that.
No worries.
Those are my questions at this
Okay.
time.
Anything on redirect, Ms. Field? Okay, I do have just a few questions I wanted to ask you.
May I turn my chair?
Yeah, yes, that's fine. So, if I understood correctly, you had whatever conversation you had with Miss Aaron back like 2022.
Yes, ma'am.
And then you had this most recent conversation that you described, I don't know, a week or two ago, leading up to this hearing, right?
Yes, ma'am.
Have y'all had any contact between that last conversation you had way back when you were trying to get her to write an affidavit and this conversation?
We did. I was her guardian in a number of cases. So, yes. And in fact, the only reason I ended up talking to her most recently is because we had a trial in Clayton County where I was her guardian. So that was the first time I had seen her in a long time. But prior to that and after all of this happened, we had a case where I was her guardian and I needed to testify in Gwinnett. So we saw each other and we talked briefly then, but not about this.
So was this most recent time the first time you guys talked about this?
Yes, that's what we were saying in the call. She said, you know, we haven't really had an opportunity to talk about it because I get upset and I start fussing. And because she didn't want to be involved. And I get that. I get it. To answer your question, yes, ma'am.
And who initiated the conversation this most recent time? Who initiated the call and who initiated the conversation?
She initiated the call and she initiated the conversation.
And tell me precisely what you remember her saying about that.
She asked what I was going to say here today, and I told her, and she said, but Bran, I didn't say that. And I said, yes, you did. And she said, no, I didn't. I said, yes, you did. And she started recounting what she said that she said, but she left that part out. And I said, well, you know, my memory is bad, so let's just agree to disagree. But I distinctly remember standing in front of my mirror, and I talked about my bed being made. And I said that she said it, and I said the part about setting her house on fire. And she said, yeah, that does sound like something you would say. So that's how that, did I answer your question?
Yeah, no, thank you. Okay. Anything else? May we excuse Miss Alexander?
Yes.
Okay, thank you. You're free to go. Thank you. Next witness?
Director calls Bonnie Stinson. Good afternoon. Will you raise your right hand, please? Do you swear or affirm the testimony you will give in the matter now pending before the hearing panel of the Judicial Qualifications Commission will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Will you please introduce yourself and spell both your first and your last name?
Bonnie Stinson, Bonnie Stinson.
Ms. Stinson, are you an attorney in the state of Georgia?
Yes, I am an attorney.
When were you barred?
October 2022.
Okay. How are you currently employed?
I am currently an associate attorney at Shoemaker and Lewis.
And how long have you been at Shoemaker and Lewis?
I was hired in June 2022, right before I took the bar.
So you've been there the entire time that you have been practicing law?
Yes.
Okay. And what kind of law do you practice?
I do family law, so divorce cases, custody, child support, and restraining orders.
And are you an associate at that firm?
Yes.
Okay.
Is the arrangement at the firm such that you work with all of the partners, or do you specifically work with one of the partners?
I work predominantly with the managing partner, Patricia Shoemaker. I also assist the other partners on other cases as necessary.
Okay. I want to direct your attention to a phone message that you received back on April 22nd of 2024 from Judge Shermela Williams. Do you recall receiving a message like that?
Yes, I received a message. I was in court earlier that day when I believe she called my office. I did not see the message from our receptionist until later that afternoon.
And how did you receive the message from your receptionist?
Whenever I miss a call, our receptionist will send me an email with the name and phone number and usually a brief message about who called and potentially what the call was about.
All right, and is that what happened with the message from Judge Williams?
Yes.
Okay. I am going to show her Joint Exhibit number 30.
Did you say 30 or 30?
30. No luck. All right, Ms. Stinson, can you see the screen up there?
Yes.
All right. Showing you J30, is this the message you received regarding Judge Williams' call?
Yes.
Okay. And who is Mr. Rodriguez?
He was our receptionist at the time.
Okay. What did you do when you received this message?
After I received the message, I immediately went into Ms. Shoemaker's office because it frankly made me extremely uncomfortable.
What about this message made you uncomfortable?
We currently had a case pending in front of Judge Williams, and I didn't see a reason why she would be contacting me alone.
And I'm sorry, I should have asked this. Do you serve as a guardian ad litem?
I do not.
Currently? Okay. So you do just litigation and
Yes.
family law matters? Okay.
Exclusively litigation.
Okay. And you testified that you all had a case pending in front of Judge Williams at the time. Had you, before the date that you received this message, appeared before Judge Williams?
Yes.
How many times do you think?
Probably a handful of status conferences, and then right after I was licensed in November of 2022, I had a final trial in front of Judge Williams.
Okay. And that would have been very early on in your career?
Yes, a month after I was licensed, actually.
Okay. So when you went into Ms. Shoemaker's office, what did you say to her?
I told her that I just received the message from David. I believe I showed her the message, and I asked her what could Judge Williams potentially be calling about.
And without telling me what she said, did you have any thoughts about what Judge Williams may have been calling you about?
I truly didn't have any idea, without going into what Ms. Shoemaker speculated. There were numerous open positions with Judge Williams' staff, and it was a thought that maybe a job offer, although I did not think that was likely because I had not been practicing very long. So I was very much at a loss at what the call could be about.
After you spoke with Ms. Shoemaker, did you return Judge Williams' call?
I waited until after 5 o'clock as instructed in the message. I think it was maybe 5 minutes after 5 o'clock. And I called the number back, and a member of Judge Williams' staff answered the phone.
So let me back up. You said a member of Judge Williams' staff answered the phone, but in the message here, Mr. Rodriguez said the included contact number is her personal cell, and she asked that you do not share it with anybody. Is the number that you called her personal cell?
It was.
Okay. And a member of her staff answered the phone, you said?
Yes. I believe it was because Judge Williams was still on the bench.
Okay. And so did you end up speaking with her at that time?
With Judge Williams at that time, no. She ended up calling me back about an hour later.
Okay. Where were you when you received the return phone call from her?
I was at my home.
Okay. And did you take that call from her?
I did.
All right. How did she begin the call?
She called by introducing herself, saying it was Judge Williams. She also quickly went into that she was not calling me and trying to use her capacity in office and title to try to influence me in any way.
And did she tell you whether she was calling about a case?
She did right after that. Okay. She did call me about a specific case. It was Whitner versus Hill.
Okay. And did she tell you why she was calling about that case?
She did. She informed me that Mr. Hill, who was the opposing party in that case, was her uncle.
At the time of the phone call, the case that she was calling about, what was the nature of that case? What kind of case was it?
That case was a contempt case. The main issue was there was some GI Bill benefits in dispute. So the parties had agreed in their divorce that any benefits from Mr. Hill would be transferred from his GI Bill, would be transferred to his son. And they had not been transferred to his son, and this child was about to start college. And so my client, Ms. Whitner, filed a contempt action against him.
Okay, and when you say your client, was it just your case?
No, it was not. It was actually Ms. Shoemaker's case, and I was assigned to assist her on that case, as I do most cases.
Okay. Have you reviewed the petition that was filed in that case prior to testifying today?
I did.
Okay. Are both you and Ms. Shoemaker's names listed on that petition?
They are. Ms. Shoemaker's name is listed first.
Okay. And your name was listed second, like underneath hers?
Yes, because Ms. Shoemaker was lead counsel.
Okay. Was either name signed?
I believe I signed it,
Okay.
the petition.
And when you say you believe you signed it, did you sign it for yourself or did you sign it on behalf of Ms. Shoemaker?
I was able to sign for myself since my name was listed as second counsel.
All right, once she identified that her uncle was the respondent in the case that you all had pending, what was the next thing that she said to you about the matter?
She immediately got into the merits of the case. She started to discuss the underlying issues. And I asked her if she was representing Mr. Hill because she immediately started talking about the underlying merits of the case.
Okay, tell us what you mean by she started talking about the underlying merits of the case.
She began advocating for her uncle. She mentioned that if this case had gone in front of her, that she would have dismissed it, that there doesn't seem to be any benefits available, and that we should just figure a way to make this all go away, and that I was a reasonable attorney, and that the attorneys at my firm were known to be reasonable attorneys, and there should be a way that we could just figure this out instead of having the case go forward.
When Judge Williams was saying those things to you, did she preface any of those comments or remarks or arguments with something like,
I don't know that it's leading yet. We'll see where it's going.
She's about to preference it with, and then preference.
I think it's a yes or no question. It sounds like that's where we're going, but
Right.
finish your question and let me hear your question.
when she made any of those statements, remarks, or arguments to you, did she preface any of those things by saying, this is what I told my uncle, or this is what he told me?
Yes.
Okay, so let's talk first about when she was talking about the merits of the proceedings. She was arguing the merits. What did she preface that with?
She said that my client had used up all of his GI Bill benefits and that there was nothing left, and that this was an impossible case, and that if it came in front of her, she would have dismissed it.
Okay. So was there anything, when you say about the merit part, what I'm trying to figure out is, did she say to you, hey, this is what I told him about the merits? Like when she started arguing with you about the parts of the...
This is all we
Sort of, yes.
Can you tell us exactly what she said when your description was the merit, when she talked about the merits of the case, exactly how she phrased it to the best of your recollection?
When I say she was talking about the underlying merits of the case, I mean that she was discussing the details of the case. So she was talking to me about what happened from her uncle's perspective. She said that she had discussed the case with her uncle, and she told me that it was her understanding that there were no benefits, and that's what she was advocating for, that the case should go away.
Okay. And when she said the piece about if the case came before me, I would dismiss it, did she explain to you what she meant by that? Was there a why I would dismiss it because?
She said, from what I understood, she wanted to dismiss it because she did not think that my client had a valid claim.
Okay. Was there a point during that piece of the conversation where you indicated that you would need to go to Ms. Shoemaker?
Yes. I expressed that several times because Ms. Shoemaker is an expert in military law. She's written a book about military law and divorce. I had not been licensed very long, and I frankly at the time was not very familiar with the intricacies of the GI Bill benefits and whether they are transferable or whether they're not. And I mentioned that I did not have authorization to engage in any kind of negotiations on behalf of my client.
Okay. Why did you feel like you needed to tell her that you were not authorized to engage in negotiations?
Because it felt like she was advocating for her uncle. I did ask her specifically if she had been hired by her uncle to represent him in this case, or whether he was planning on getting counsel to represent him, because she was advocating that the case should be dismissed.
Did Judge Williams ask you to agree to an extension for the time frame for her uncle to file an answer?
She did. And I said that I thought a 30-day extension would be reasonable, but again, I would need to have a formal request from Mr. Hill in writing, since she told me she was not representing him, and that I would still need to speak with Ms. Shoemaker and my client about that issue.
And did you tell her that there was anything her uncle needed to do?
I mean, I think I probably told her that her uncle needed to call the VA if he believed there were relevant documents that proved his case, and I also encouraged her to inform him to hire counsel.
Did you eventually receive a request for an extension from Judge Williams' uncle?
I did.
I'm going to show you Exhibit J 31. Can you tell us what J31 is?
Yes, this is the email that I received from Mr. Hill,
What did you think when you received this email?
that Mr. Hill did not write this email.
Why?
If you keep moving it, I can't read it.
I'm sorry. There we go.
Well, to begin with, if you scroll up just a little bit to where you can see the subject line. So on the subject, it says Kimberly Whitner, formerly known as Kimberly Hill versus Corey Hill, CAFN, and lists the civil file action number. Most pro se parties do not title an email about a case like that. That's especially using the CAFN, which is the abbreviation for civil action file number. That's not something a layperson normally knows to use. Also, I thought the tone of the email was incredibly formal. If you look at the bolded section at the bottom of the page here, it says, nonetheless, I'm not challenging service. Most lay people don't understand what it means to challenge service. The way that he speaks in this email is incredibly formal, sophisticated, way above what I would imagine a pro se party to be able to articulate. Even smart pro se parties.
Was Judge Williams' uncle given an extension for his answer ultimately?
He was given a 30-day extension.
At the time that this happened, did you, outside of appearing the few times in front of Judge Williams, did you know her?
No, not personally.
Okay.
What did you know about the background of the uncle, if anything?
Nothing. I did not know that they were related in any way until Judge Williams told me.
I mean, did you know his military service?
I knew he was a military service member.
Did you know his rank and MOS and all that kind of stuff?
I did not.
Okay. So he could have worked in the legal office or been a paralegal in the military?
He could have. However, in my experience, like I said, even very intelligent, smart pro se parties don't articulate cases like this if they're not an
Us
attorney.
non-lawyers are just not that smart. So.
Well, no, that's not having anything to say about his intelligence. It's just the language that he uses, the way it is crafted.
I understand. I wasted 11 years in college.
So as a result of, I'm sorry, how long did the call between you and Judge Williams last?
About 45 minutes.
Okay. About how much of that 45 minutes would you say that Judge Williams was talking?
Oh, a majority of it. Probably 30 minutes. 30 of the 45.
Okay. During the time that she was talking, were you often responding, or how were you handling yourself during that portion of the call?
I was very uncomfortable throughout the conversation, and I did not want to commit my client to anything. I also, like I said, was not frankly sure of the answer about some of the GI Bill questions. I didn't have the expertise at that time. And I didn't feel comfortable discussing in too much detail about that issue. So I just tried to keep it very vague. I tried to just say, well, I'll talk to Ms. Shoemaker, I'll have to talk to my client, I'll have to look into that. Not very agreeing to anything that Judge Williams was saying.
Did you let Ms. Shoemaker know about the call?
Yes, I called her immediately after I was on the phone with Judge Williams.
Okay. And did you have continued involvement in this case afterward, after the phone call?
No, we mutually decided that I should not work on this case anymore after that phone call.
And why was that?
I did not want anything to affect my client's case. So I did not want to touch the case any further. I did not want to appear in court on that case any further. I wanted the case to shine on its own merits and not affect her case at all.
And who was the case assigned to?
Judge Kevin Farmer.
Okay, all right. I think that is all I have. Thank you.
Any examination for Ms. Stinson? Okay.
Thank you, Judge. Good afternoon, Ms. Stinson. How are you?
Good
Counsel?
afternoon. I'm good, thank you.
Where'd you do your schooling?
I went to Georgia State Law School.
Okay. All right. Are you from Georgia?
I am. Well, I was born in Florida, but I've been here since I was 6, so I call Georgia home.
So not a gator, but a dog?
No,
Or are you a dog?
War Eagle, Auburn fan. My
Oh.
family's from Birmingham.
Okay. Okay. All right. I won't tell anybody, although this is streaming live, so people
I
don't
know.
know.
I know. They all know now.
So I want to talk to you a little bit about your testimony, if that's okay.
Sure.
And I know that at some point you indicated that there was a message left in your office that Judge Williams had called you.
Yes.
That at the time that Judge Williams had called you, that I believe you had a pending case, or at least your firm had a pending case in front of her. Is that true?
Yes, Miss. I mean, I think the firm probably had more than one case, but I specifically had one case pending in front of Judge Williams.
All right. Do you recall when the last time you had appeared in front of her related to that case?
I believe it was maybe about a month prior. I believe there was a hearing in March of that year on that case. It was definitely in the spring before that call.
Okay.
And we were waiting on an order, so.
Okay. So it was a final hearing, waiting on an order. Do you know when the order came in?
We actually had kind of a second final hearing on that case later, and then we received the order in December.
Okay. All right. How many times had you appeared in front of Judge Williams?
Like I said, maybe a handful of times.
Or pleasant to appear in front of?
For the most part, yes.
Not disrespectful?
I wouldn't say disrespectful. I would say sometimes she could be condescending.
Okay. Was she kind to you?
Sure, yes.
Okay. She seemed like she knew the law?
From all appearances, yes.
Okay. I'm not saying you agreed with all of her rulings,
Sure.
But did she ever rule on your cases that you appeared in front of her?
Yes.
Did you ever appeal any of those rulings?
I did not appeal. I did file a motion for reconsideration
Mhm.
in the case that I had pending at that time.
Okay, fair enough. Of course, your Ms. Attorney Shoemaker also appeared in front of her several times, I'd imagine, and other lawyers in your firm?
Oh, yes, a lot more than I did because I've only been licensed about 2.5 years.
Okay, all right. Did you always want to go into family law?
No.
Okay. And not telling too much of your business, is that your plan to stay there, or do you have
Yes.
other? Okay, all right. Very important part of the practice of law, no doubt. And so I do want to talk to you about the conversation, if that's okay. I recall specifically that at some point you testified that when Judge Williams was advocating on behalf of her uncle, you indicated that she said on one point that my client ran out of GI benefits. When you said my client, were you referring to my client had used all the GI benefits?
I was talking about my client, so
All
Miss
right.
Whitner in that case.
Okay, so she wasn't representing that she was representing, she didn't indicate to you that she was representing her uncle, true?
That is correct because I specifically asked her that question.
Right. And so the my client reference was essentially Judge Williams saying that she was informed by her uncle that your client had used all the GI benefits. Is
Yes,
that fair?
that's correct.
Okay. And you said that the call was about 40 minutes, 45 minutes?
Yes.
Okay. And I'm assuming that you would agree that that's a lengthy call.
Yes.
You talked about other things other than her uncle's case, true?
We briefly talked about, I believe her father had passed when I conveyed my condolences.
Sure.
And I believe her, part of the reason why she was advocating for an extension for her uncle was because either his mother or his sister was on her deathbed and she passed.
Fair. All right. Look, when I used to work for a law firm, there were partners and there were associates. The partners got paid all the money and the associates did all the work. I'm not trying to belie anybody there in your firm, particularly your partners, but I mean, were files or cases set up where there was a partner assigned to the case and an associate assigned to the case?
There was, but Ms. Shoemaker and I work cases together.
Okay, fair enough. And so to the extent that you work cases together, is it fair to say that you both would be on the pleadings?
Yes.
And to the extent that you were responsible as the associate to file the pleadings, sometimes you would sign those pleadings. Is that true?
Well, yes. If my name's on it and I can sign it easier instead of bothering Ms. Shoemaker just to sign a pleading that she's already approved, then I will just sign.
All right. And in this case, there were pleadings that you executed. Is that fair?
The petition, yes.
Okay. Were there any other pleadings that were filed in this case prior to the call being made by Judge Williams?
No.
Okay. Did you arrange the hiring of a process server to serve the papers or the pleadings or the contempt pleading on Judge Williams?
No, that would have been our paralegal.
Okay, fair enough. But there's no doubt you would contend that certainly your name was on the pleadings. Is that fair? And your signature was on the pleadings, true?
Yes, but everything that was filed would have been approved by Ms. Shoemaker, and then we would have sent it to the client to approve before we would have filed it.
Okay. Did she never directed you to dismiss the petition, did she?
Ms. Whitner?
No, Judge Williams.
She directed me, well, she didn't direct me, I would say. She told me that she believed the case should be dismissed and go away.
Sure, fair enough. But she never said, hey, you need to dismiss this case.
I don't know if she used that exact phrase.
Okay. Certainly it wasn't when she made comments about any dismissal. You didn't take it as her directing you to dismiss it or ordering you to dismiss it, did you, ma'am?
I didn't take it as an order, but it was strongly emphasized that if this particular case had gone in front of Judge Williams, she would have denied the contempt or dismissed it because, in her words, it was an impossible case.
That's fair enough. All right. If I can just have a moment.
Sure.
Okay. Ms. Stinson, thank you for your time. Those are my questions.
Thank you.
All right.
Redirect?
Why did you use the word condescending to describe Judge Williams?
Often when I've been in front of Judge Williams's courtroom, she will often give it in her rulings, she will often go on a very lengthy, what I would call maybe a monologue about her opinion of the parties. For example, that case that I had in front of her in November of 2022, my client had alleged that the minor child issue was a victim of rape. She went on for about 20 or 25 minutes in her ruling about her belief of the credibility and her background in sex crimes, and that she did not believe my client. And it went on longer than it should have. It went beyond the point of, as a judge, I don't believe you, I don't find you credible. It went far beyond that. I've seen her take personal attacks at attorneys. I have seen her just talk down to attorneys and parties on multiple occasions.
Ms. Shoemaker is not here, but can you give us an idea about how long she has been practicing family law in the metro Atlanta area?
Yes, she has only ever practiced family law. She's been practicing for, I believe, about 15 years.
All right, that's all I have. Thank you.
Anything else, Mr. Banks?
No, thank you.
All right, may we excuse Ms. Stinson?
Yes, Your Honor.
Any objection to that? Okay, thank you so much, Ms. Stinson. You're free to go.
Thank you.
I know we are at 5, but you also said you had witnesses to get us to the end of the day. Did you have like one more that you were wanting to try to get in that we could finish up with? Or?
We do.
Okay.
We have one more.
All right, well, let's go ahead and call that person then, and we'll see if we can finish that out.
I'll call Kelly Reese.
All right, Ms. Reese, will you raise your right hand? Do you swear or affirm that the testimony you will give in the matter now pending before this hearing panel will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, I am going to, I'm sorry. Will you state and spell your name for the record?
Sure. Kelly Reese, Kelleyreese.
Okay. And Ms. Reese, how long have you been an attorney?
About 17 years, a little over that.
Okay. And how long have you practiced family law?
The full 17 years.
Okay. And is that mainly here in the metro Atlanta area?
It is, yes.
All right. I'm going to bring your attention to a specific case that you handled in front of Judge Williams. Is that the Ritter versus Lopez case?
It is. It started with Judge Edwards and then became Judge Williams.
Okay. I guess Judge Williams took over the case when she took the bench.
Correct.
And took over Judge Edwards' caseload. Is that
Correct.
correct? Okay. Do you know that case number off the top of your head?
I do not.
Okay. May I approach the witness, Judge? When reviewing that notice, refresh your recollection. Counts 13 and 14.
Of the first set or second?
Of the first set of charges, and that's paragraphs 79 through 86.
Thank you.
These are counts that
You admitted to count 13 and not count 14.
It's right there. No, he's right. I think he's right. Kind of stipulation thing.
Did you say
They
she-
added 13.
I showed that they did, she did admit 13 and 14.
Okay. Do you have any more questions about that?
No, I just want the record to be clear.
Okay.
Admission, excuse me, we did admit to counts 13 and 14, just one.
Yes, that's clear. Okay. And can you tell me that case number?
Sure. 2019 CV 324517.
Okay, thank you. And can you tell us, let's kind of start with, I understand that case is a 2019 number, so it was filed in 2019, is that correct?
It was.
So kind of let's skip forward to when you had that final hearing. When did that take place?
So it was the summer. The first part of it was in the summer of 2021, I believe. It was 2021 or 2022, but
Okay, and if you look at that notice that I handed
sorry,
you,
yes,
I believe
summer of
that's-
2021. It was so we had a total of 7 days of trial. The first 5 were consecutive days starting July 19th.
Okay, and that's J19 that I've handed you, just so the record's clear.
Yes.
Okay. And so you didn't finish that trial in July, then what happened?
We were reset to come back in September to conclude it.
Okay. Before you finished that hearing, what happened?
You mean before we left or got reset?
Yes.
Was there a ruling or?
Was there any sort of ruling in July that happened?
There was no ruling in July because we had not completed the case. Judge Williams ordered Mom to bring the children back with her from California when she returned for the second portion. And I do remember at that time, Judge Williams had asked both attorneys to send proposed orders to the court before the next set of days so that she could make a ruling after we had concluded the case.
Okay. Did you submit those proposed orders as you were asked?
Yes.
Okay. And I'm going to show you J21.
Yes.
Is that, scroll up so you can see the number. Is that the proposed order that you sent?
That's the
Sorry.
email that had the attachment with proposed orders in Word, yes.
Okay, and that was September 10th of 2021?
Correct.
Okay, and that was before you concluded the final hearing?
It was, I want to say the final 2 days were September 17th and 18th maybe, or the 14th, somewhere in that realm.
Okay. After you concluded that final hearing, what did she rule from the bench on that date?
Well, Judge Williams did legitimate my client at that time, but stated that she wasn't ready to make a ruling with regard to custody and visitation.
Okay. After that happened, did you have to do anything to get an order in that case?
Well, there were a few times that I think I resent orders just to sort of tap into the court to remind them that we had presented orders. I believe that there was also a time where the staff attorney changed, so we resent everything to the new staff attorney. But I think that I reached out a couple times after the hearing.
Okay, and I'll show you J22. Is that you resending that proposed order to the new staff attorney?
That's
Ms.
correct.
Bowles?
That's correct.
Okay, and is that January 27th of 2022?
That's correct.
Okay, at that point, you still couldn't get an order. What did you do?
I think at some point I filed a motion just based off of the code section that stated that if we were in a county that had a certain number of population, that the court was to make a ruling within 90 days of the evidence closing. So I believe I filed a motion pursuant to that code section, just sort of hoping to trigger a response.
Okay, and is this the email where you sent that courtesy copy to Chambers with
That's
Ms.
correct.
Bowles, who was her staff attorney, is that correct?
That's correct.
Okay, and then J20 is that actual motion requesting that order, is that correct?
That is correct.
Okay, and in here, you mentioned that your client had very limited contact with his child, is that correct?
His children, yes.
Okay, and so it's been, at the point that you filed this motion, it's been over almost a year since you first started that final hearing, is that correct?
That's right.
I think it's a total of 8 months since you had concluded the final hearing. How much time had he been given with his child?
So this was a legitimation case, so it was a little bit different in that regard, but essentially the only order that was in place was prior to when it transferred over to Judge Williams that gave him 10 minutes of FaceTime each week. So that was all he was getting. During the course of the litigation, there was a forensic custody evaluation, and in order for that individual to have contact and see dad with the children had to see dad before that, and it was done in a supervised setting. So I believe he had a total of maybe 8 hours during that period. And then after we completed the second portion of the trial in September, Judge Williams afforded my client a few hours with the kids while they were there. So that was the extent of the amount of time that he had from a physical contact standpoint over the course of that time. After the hearing, he would have had those few hours of physical contact in that span.
Okay, and then after you filed that motion, did you quickly get an order?
I did not.
Okay, do you know at what point you did get an order in that case?
I believe I got it in 2023.
Okay, if I have a copy
Roughly.
of that. Would reviewing that order help refresh your
Sure,
recollection?
yes, it would.
May I approach?
You may.
So, January 19th of 2024.
So a year and a half after you filed that motion for an order is when you got that order.
Correct.
And between that time, had anything changed with your client and his children? Had he gotten to see them anymore or anything like that?
No.
Is your client having to pay you during this time to reach out and kind of ask the judge for the order, or are you doing this for free?
Well, candidly, he owes me a pretty large amount of money, but I still continue to reach out whether or not that was paid for. But
Okay.
How many different counties do you practice in?
all of Metro, so Fulton, DeKalb, Gwinnett, Forsyth. I often go to Fayette.
So all of them have more than 100,000 population?
That'd be correct.
How many on those, not Fulton, in those cases in the other counties, how many cases do you have where it takes 90 days or more for motions and whatnot?
I would say that specifically, I'd probably say DeKalb County. I've had an order that came out maybe 4 or 5 months after a trial.
Is that the longest you've waited anywhere
That'd be
other
correct.
than the, okay, thank you.
And I just want to be clear do you remember the very last date of that final hearing?
It's either September, I want to say maybe September 18th of 2021. September 17th and 18th were the last 2 days.
Okay. And between that very last date of that hearing and the time that you got an order, how much time did your client have with his child?
So physically in a room with them, a few hours. And then outside of that, he was able to contact them for 10 minutes on FaceTime on Sundays.
Okay. I have nothing further. Thank you.
Any cross-examination?
She ruled against the father in this case?
Well, I don't know what you would mean by ruled against the father.
Didn't give him everything he wanted.
Well, in my experience, nobody ever gets everything they want. He got ample parenting time.
Sure. Okay. The case that you referenced in the cab that did you send proposed orders in those cases?
Yes.
And how long were those proposed orders? Do you
How
recall?
long were they?
Mhm.
It was specifically was a modification of custody and parenting time, I believe. Certainly not as lengthy as this. Most orders I send are not as lengthy as this case.
Sure. In fact, the proposed order that we're sending in this case, 87 pages and 50 pages on the opposing side. Does that sound about right?
That sounds about right.
And that's a whole lot of proposed order. You agree, right?
Sure.
And the actual order entered is about, what, 25, 26 pages?
So, something, I think 26, yes.
This was an extensive litigation, would you say?
It was.
At some point, you indicated that there was a bifurcated final hearing where some of the proceedings occurred in July and then the end of the proceedings occurred ultimately in September, correct?
Correct.
Did the parties allot or advise the court about the timing of how long it was going to take to try?
We did.
Okay. And did y'all get that estimate right? Or I'm trying to understand why the case was bifurcated. Can you go into that a little bit?
Sure. Well, actually, if you look on the initial trial notice, it was scheduled for 8 days, which was what we asked for.
Uh-huh.
And I believe so the court, as happens, and that's not uncommon, doesn't
Okay.
have 8 consecutive days to
Sure.
try a case. So Judge Williams set us for 5 consecutive days, and then we weren't sure when the next portion was going to be. We were actually supposed to get 3 days, but I believe Judge Williams had a family issue, and so we went forward with just the 2 days.
Okay, fair enough. Is it true that your client asked for full custody?
I believe he was seeking custody.
Okay,
Yes.
all right. And he did not get custody?
He did not get custody, no.
All right, but he did get ample visitation time, true?
He was legitimated, which mother objected to that, so he was legitimated, and he did get ample parenting time, correct.
You've reviewed the order, obviously.
It's been a while, but
Yeah,
yes.
but you did that in preparation to assist your client in understanding the order, true?
Yes, well, I drafted, some of this is what I also sent to the court.
100%
Yeah.
agreed. You didn't appeal the final order, did you, ma'am?
I did not.
Okay. If I can just have a moment. At some point, you recall the time when Judge Williams, or then candidate Williams, was running against then incumbent Reeder.
Sure.
You supported Judge Reeder at that time, did you not, ma'am?
to be honest with you, I don't recall.
You don't recall making
By
a
support, tell me what you mean by that.
financial contribution on behalf
Not that
of
I
her?
recall.
Okay.
To be candid, my former partner sort of handled campaign contributions,
Sure.
so.
Who was your former partner?
Corinne Burney.
Okay. And what was the name of your firm
Bernie
at
and
that
Reese.
time? Bernie and Reese?
Mhm.
Okay. If there is a campaign contribution in the name of Bernie and Reese, it would have likely been your former partner?
She would have written the check.
Okay.
Yeah.
All right. Okay. Those are my questions. Thank you.
Okay. Anything else for Ms. Reese? Ms. Stone?
Nothing further.
May we excuse Ms. Reese?
We would ask that she be excused.
Any objection to that? Thank you, ma'am. You're free to go. Thank you. Any further witnesses for today?
No, Your Honor.
All right. So for planning purposes for tomorrow, I know that when we started on Wednesday, you indicated you thought you could get your evidence up in 2-ish days. So we've now had 2 days. What do we have left on your side so that these guys know to plan to get some folks here for tomorrow? When do you think you might finish?
My hope would be that we would rest, if I could have just one moment.
Sure.
I think I should rest by lunch.
Okay. All right, so then you all just know, that you'll need to just make sure you've got folks here for, lunch on.
So, just for scheduling purposes, because, I try to do my best not to have witnesses waiting. Is it fair to have people here at 12:30, which,
I'm deferring to, probably, you think you'll take us till lunch by the time we get started at 9?
So I have one witness that would just be an impeachment witness, which I would like to, I don't want to call that witness and aggravate the panel, but I think it's important. So if I do call that witness, I think we will be close to lunchtime. If I don't, I will be done before lunchtime.
Why do you think we would be aggravated with the director?
I have no idea. I don't know why I said that. My investigator. Yeah.
If you were not to call that witness, when do you think you'd finish? We can always take an early lunch like you guys did today. If you're talking about, what I don't want to have happen is just have us start at 9, finish at 10:15, and then we're just in a dead space for 2 hours with nothing to do. So I just want to make sure they have their witnesses here early enough if that could potentially happen.
I would think if I don't, I would finish probably at 10:30.
Then I think you probably should have someone here before 12:30.
if I may make this request of the court, and look, I'm going to do whatever the court tells me to do. I know we're not going to finish our case in chief tomorrow, based upon the witnesses that we have. Is it possible that the JQC rests its case tomorrow, and then the hearing panel permit us to recess, allow the JQC to respond to the pending motion, and then we come back at the end of the afternoon, and I'm not trying, look, I'm gonna do whatever the court tells me to, but.
Other than we lose half a day that we've scheduled to
Fair
be
enough.
here is the only.
And I
No, I'm not,
respect
I'm not
everybody's
saying one way or
time.
the
I
other.
really do, and it was just a thought, that's all.
How many witnesses do you anticipate calling?
Our case is, I think our case will take I don't think it's gonna take a full 2 days. I think there are about 9 witnesses that we need to call. Having said that, we are doing all we can to pare that down, because most of the witnesses are in mitigation. And so there's some mitigating evidence that we believe that the hearing panel needs to hear. But there are also some witnesses that will speak to some other issues that have been brought up.
Well, why don't we take 5 minutes? Let's recess this proceeding for the evening. Let us just talk about scheduling, and then we'll all come back and reconvene in just a minute.
Look, I'm happy to have witnesses here. In fact,
Okay.
I've talked to a couple of them already,
I mean,
and
that's my preference.
look, if that's your preference, I don't want to.
But we'll go talk.
Okay.
Okay? All right.